Good morning, everyone. Going ahead and get started now. People can still trickle in as this will be recorded as well. I wanted to start by thanking all of you for attending the Saturday panel of the Western New England Law Review's virtual symposium, New Abolitionism, Ending Civil Immigration Detention and Criminalization, Policy, History, and Legal Strategies. Along with my fellow symposium editors, Cassandra Gonzalez and Caroline Foley, we would like to acknowledge the generous support of the Western New England University School of Law administration and staff. We would like to thank Dean Sudasetti, Director of the Center for Social Justice, Ariel Clemmer, Professor Harris Freeman, Professor Lauren Karasik, Admissions Officer Manager Marcella Haynes, the members of Volume 43, and the Law Review Advisory Committee for their assistance in planning this event. Most importantly, we are grateful to our panelists who will be speaking today, who each day make a difference towards the goal of ending immigration detention and criminalization. And if you have any questions or comments as attendees, please submit them in the Q&A. When I found out that the symposium topic was going to be immigration, I immediately applied for the position of symposium editor. I had just started interning for community legal aid in the immigration unit here in Springfield. I learned so much there, and I can never repay them for the information that they taught me. Prior to that, the only thing I ever understood about immigration came from the media, my family, or the social circles I ran in, but not from my own understanding, not from my own eyes. And having been a social crusader my whole life, it was the hardest thing to realize that I myself might have a little implicit bias in me. And I had no plans in law school to do anything related to immigration law, but I knew that I had to take an active role in becoming educated to face any possible bias. And you know what I found out? I'm actually not biased. I'm mad. I'm mad at the inhumane and unfair immigration enforcement system. And I myself want to be a part of building one that upholds our nation's values of due process and equality for all. Together, we can create fair and achievable paths to citizenship for undocumented immigrants. And that's why these events are so important, so that people can come together and have a discourse and become educated so that we can all be mad together and use that anger to take action. During my experience at Community Legal Aid, it was my great pleasure to work for attorney Claudia Quintero. Claudia Quintero will be our moderator today, and she is the staff attorney at the Central West Justice Center, an affiliate Community Legal Aid who serves people from Central Mass to the border of New York. Attorney Quintero runs the Migrant and Seasonal Farm Worker Project, which represents farm workers across the entire state of Massachusetts in a range of legal issues, including immigration, labor and employment, housing, family, and benefits law. She routinely provides Know Your Rights training to the community on issues related to immigration and workers' rights, conducts outreach to farm workers directly, and engages in legislative advocacy on behalf of farm workers. And in 2018, she published Ganging Up on Immigration Law, Asylum Law and the Particular Social Group Standard, Former Gang Members and Their Need for Asylum Protection. She's also been recognized by the Massachusetts Supreme Court with the Adams Pro Bono Publico Award for her work on behalf of immigrants. She is a proud alumna of Western New England Law and its law review, and she is currently teaching a class at our law school. It's called Law and Social Change.
Thank you, Audrey, for the introduction. Welcome, everyone, and thank you so much for attending the Western New England Law Review Symposium, New Abolitionism, Ending Civil Immigration Detention and Criminalization, Policy, History, and Legal Strategies. We're so glad to welcome you to today's panel, which promises to be chock full of conversation. You hear from 6 amazing panelists, all of who have a unique perspective to the work they do to end civil immigration detention and criminalization. We invite you to send us questions via the chat box or the Q&A button, whichever is easiest for you. I'll be monitoring that throughout the panel today. Don't be shy. I also want to thank the editors and the Western New England Law Review for all of their hard work and dedication in putting this very important symposium together. the Western New England School staff and faculty, yesterday's panelists and moderator for the time and contributions to the conversation, and of course to the panelists today. Thank you so much for inviting me and allowing me to moderate this panel and be a part of this event. The Western New England Law Review, the Western New England, and immigration have a special place in my heart, and I'm grateful that they've all converged this bright and not very early, but not very bright Saturday morning. Today, I want to share some of my own experiences with immigration and the immigration work I do, provide some context for the panelists' presentations, and leave you with something to think about as you consider and move beyond the symposium. Yesterday's panel discussed the various ways that non-citizens' rights are restricted through various forms of monitoring, of course, the effects of COVID-19 on detainees. Today, we will be exploring ways to challenge government action, how to effectively organize community to accomplish legal change, and why representation really matters. I want to touch on the representation part a little bit because for me, that part is actually really personal. Without legal representation of immigrants, detained and non-detained, many of us would not be here with you today, and myself included. And this is the reason why this work is so important to me. I myself am an immigrant. And for a long time, I was an undocumented immigrant. It was through the representation of an incredible immigration lawyer who was so zealous in her advocacy that I was able to acquire legal status in the US and attend law school and become a lawyer. Were it not for her and her representation and willingness to take my case on, I really don't know where I would be right now. And so for me, I understand the fear of deportation. I was never detained, but I did live in constant fear of being found out and ultimately deported, and living with the shame and the stigma of being illegal, as that was the term that was constantly that I heard, with this idea of having to exist in the shadows, and the value that I provided to this country diminished to my legal status. I lived this way for the first 17 years of my life, and when I acquired legal status in the United States, I vowed that I would use this opportunity to represent others like myself and help make things better for immigrants, to empower people to have autonomy over their representation. So that brings me a little bit to the work that I do now at Community Legal Aid Central West Justice Center, where I represent migrant and seasonal farm workers across the state of Massachusetts. And in my work there, I really do a lot of immigration work. I work with communities. A vast majority of farm workers here in the state are undocumented workers who come from countries where they've primarily done agricultural work. And so here, when they come to the United States, a lot of them are sought out to work on the farms, or they seek out to work on the farms because it's a skill that they have. And so in my representation of farm workers, I really go out into the community and talk to them about their immigration rights, counsel them on ways that they can empower themselves and be at the ready when they become eligible for immigration relief, if any. I do a lot of consultations with clients to inform them just generally of the law, so that when they go out and talk to anybody, they really have a sense of what it is that they're talking about. We do a lot of humanitarian immigration work at Central West Justice Center, meaning we represent clients in asylum cases, U visa cases, trafficking cases, special immigrant juvenile status for young minors, and derivative cases of those cases, and VAWA self-petitions for victims of domestic violence. So we work a lot with clients who really struggled and seen a lot of things in their lives, and we try to understand the community. So as part of that, I really get to know my clients. I spend a lot of time with them. I get to know who they are outside of work. We build a lot of a shared competency and understanding, because the minute they hear me speak to them in Spanish, they're like, oh, you speak Spanish? Like, where are you from? And, I say to them, well, I'm from Mexico, and I was an immigrant myself. And so they see me as somebody that they could potentially be as well. So working with the community is really important to me. And doing this work is really important to me. I don't see myself really doing anything else, really. I've been with Central West Justice for 4 years, and I really like the work that I do. It's important work representing immigrants, because it is a known fact that the immigration system is broken and dysfunctional, and the application of immigration law by government agencies is what we lawyers like to kindly refer to as arbitrary and capricious. The less we refer to it as another name, and we risk getting disbarred. But it's just a program or a system that doesn't work. Immigration judges have so much discretion that sometimes when I take on a case in front of an immigration court, it really does matter who your judge is going to be, and even what mood they're in when you get there that morning. And so when clients say to me, well, what are my chances? I have to say to them, it's really hard to say. It really depends where your case is going to be. Is it going to be, in a court where we have friendly judges who understand the issues and are sympathetic to them, as sympathetic as an immigration judge can be? Or are we going to be in a court where we have an immigration judge that just does not have any sympathy for the issues we're presenting? And so it's really hard to advocate for clients when the system is so arbitrary in its application. Fighting against government immigration action requires ingenuity, a firm understanding of the law, and tenacity to keep fighting and keep going. There's no better example of standing up against oppressive government action than when the Trump administration implemented the Muslim ban in 2017, and lawyers rushed to airports to set up mobile legal offices, and other lawyers rushed to courts to file injunctions and court actions to implement injunctions to stop the ban. It really requires a strategy that requires strong thinking and strong coalitions, because no one person can do this alone. And so for me, the most important advocate in pushing for change are immigrants themselves. Organizing the community involves educating and empowering the community. We lawyers cannot effectively advocate if we don't understand and listen to the community affected by these issues. United We Dream, the largest immigrant youth-led network, is a good example of organizing led by individuals who are directly impacted by this issue. And today we'll hear from somebody who is an immigrant advocate themselves. And as a law professor who teaches law and social change, I always remind my students that to be an effective community lawyer, we have to really engage with the community and understand the community, listen to the concerns, and empower people in not just taking back power, but shifting power from the powerless, from the powerful to the powerless. And so lawyers play an important role in challenging government action, but we don't play the most important role. We play a supporting role. And we have valuable legal knowledge that allows us to accomplish legal change and understand this very complex web of immigration law. The forms are complicated. The law is dense and hard to read, but people are not just that, right? We're individuals who live with fears and carry a lot of experience and knowledge as immigrants in this country. One of my favorite quotes that I'll leave you with in my guiding principle is by Leela Watson and an Aboriginal rights group. They're from Queensland. And together they came up with this quote that says, "If you've come here to help me, you're wasting your time. But if you've come because your liberation is bound up with mine, then let us work together." And that's really how I like to think about my work. How can we work together to make the system a better place for all? For immigrants, especially in this, coming out of this climate of extreme government oppression, and to empower clients to have autonomy over the issue themselves. So again, I remind you to please send your questions to the chat, to the Q&A, and be, involved in the symposium. We couldn't be here without you, and we're so happy you're here. It is now my great pleasure and honor to introduce the first panelist of the morning, Mr. Ravi Ragbir. Ravi Ragbir is the executive director of the New Sanctuary Coalition in New York, one of the largest coalitions in the city focused on immigrant rights. Through his own struggle to remain in the US, Ravi became an active in supporting other immigrants who are facing similar challenges. Today, Ravi is a nationally recognized leader in the immigrant rights movement, and he's a community educator, spokesperson, and advocate himself. When Ravi was released from immigration custody, he immediately volunteered at Families for Freedom, a network of immigrants fighting deportation. He went on to serve as the chair of the board of directors for the organization. He has trained other advocates, allies, community organizers, and elected officials about immigration issues and how to reform the deportation system. He has met with members of Congress and administration officials and has testified in front of the New York City Council to discuss detention and deportation policy. Ravi, welcome.
Thank you, Claudia. Claudia, I don't know why I'm here, because Claudia actually gave my presentation for me, especially in the last 5 minutes, which is about community, working with community, right? But I also want to thank Audrey, Caroline, and Cassandra for inviting me to be here, and for all of you who are listening to this important issue. I normally don't introduce myself a little bit more, but I think I need to, because this is going to be part of what we need to discuss. I have been fighting my deportation since 2006. I spent 2 years in immigration detention. When I was released, I was under ISAP, where I had an ankle monitor. I was placed on a 12-hour curfew. I had to report 3 times a week to immigration, right? And they had to come to my home every other week unannounced. So how was I supposed to be able to survive? How was I supposed to take care of myself when I had to be at home if they had to show up? And the reason why I am in this situation, because I have a criminal conviction, and I want to be clear about that, right? We are in this problem because we have this good and bad immigrant issue that was highlighted in 2010, where Arizona said, immigrants were saying, well, if you have a criminal conviction, you should be deported. And then I'm sorry, I want to keep track of my time, so let me just put my timer on. But then what happened? So the people who were working and good immigrants were saying we should be allowed to stay here, except in 2010, Arizona said once you're an immigrant and undocumented, you're a criminal, right? So the good immigrant, bad immigrant actually facilitates our own deportation. But I also want to push back at Claudia for one instance, and this is not just Claudia, it's all, and a lot of lawyers and a lot of people who talk about immigration as being a broken system. It is not a broken system. It is intent. The intention is to deport. The intention is to destroy. And you saw that specifically in the last administration, where under the Obama administration, they would do raids and they would pick people up, and they would not make a public announcement about what they were doing. But under the Trump administration, they were very public about what they were doing, because in addition to a physical warfare of coming after immigrants, they were doing psychological warfare. So that every time they made it public about, oh, we are going after, we're going to come into New York and raid the communities, people got terrified. So, when you are in this terrified moment, you don't know how to respond. You're in this constant trauma and fear. As Claudia said, when she was undocumented, you don't know, you may want to leave, but, so this part of the immigration policy and the way it works is to cause you to leave so that they don't have to do it. But I also want to say why part of my introduction was I talked about reform. I have shifted completely. It is not about reform. We cannot talk about reform. No, I'm not going to push back at all the things that is happening right now under the new administration. We'll talk about that. But let me say why I have to shift now. It is not reform, but for me, repeal. The immigration policy started in, the roots of immigration started on racism, started on the Chinese Exclusionary Act. And I know there were other policies just prior to that that also started the root of that. But the Chinese Exclusionary Act was the first immigration policy. Right? That is based upon not what about anyone did, but on who you are. It is to exclude you because of specific characteristics and that you should be deported. Has that changed? Has that changed? Of course not. We continue to see that if ICE comes into this room, the first person the people they will ask, they will target for first questions about, are you born here, is people of color, right? Myself, skin color. That is racist. And you know, when there's a book called Hitler's America. I didn't read the book, but people were discussing it, and it was said in the book that when Hitler observed the immigration policies of America, he knew this is the tool that he needed to implement to further his mandate. The immigration policies, first they made them the other, right? Oh, they are not us. We should be targeting them, and we should get rid of them, etc. Then they tried to deport them. They couldn't deport them fast enough. And then you had the detention centers, the concentration camps. You know, the concentration camp was just recently, we stopped the concentration camp under the previous administration in Tornillo, Texas. Now they reopen it, right? I'm not going to get into that. That's a whole new topic by itself. But they had concentration camps, and we see that over 45,000 people, just because of the immigration, just because of this piece of paper here, right? This work authorization or whatever determines their humanity and how they are treated, and that they are detained every single day. There's something called ICE is told that they have to have 34,000 people locked up every single day. Otherwise, Congress is going to check to bring them up to what they would hold them accountable to that. So when you are saying broken, it doesn't mean broken. Now I looked at I just actually read when they posted the topic, right? New abolitionists, ending civil immigration, detention, and criminalization, policy, history, and legal strategies. I have a problem with that headline. I do have a problem with that headline. It is missing one key component that is very, very vital for change, and that is legal and community strategies. Completely missing, and Claudia hinted to that, right? When she talked about the Muslim ban, it wasn't just lawyers at the airport. It was thousands of people there who were protesting, who made it an issue. After 2016, and we had the new administration, the first things that came out of everyone's mouth, including the ACLU, wasn't about legal strategies. It's about sanctuary cities. Sanctuary cities. Because based upon the previous, the campaign promises of the president, we knew that they were going to violate a lot of policies. And even though they were legal, they were going to take it to court and challenge that. What was the harm that was going to create before we got a resolution in court, right? So you needed to find a safe place for people to stay or for people to have, so that they can start understanding what was happening and then challenge those things legally. Now, when you talk about, I may be rambling and I may be jumping all over the place here, and you know, why are you listening to me? As I'm not a lawyer. Remember, I'm not a lawyer, and I say that very clearly. In fact, my wife is a lawyer, but I'm here to challenge the lawyers. I think there's a problem with the way things have been done. You know, we have been challenging the lawyers for many, many years. Because again, Claudia did my presentation for me, because it is not about only listening to the community. It is actually shifting the way you work with them. So I'm not a victim. You're not here listening to me as a victim. I'm here as an advocate. Two different things. I'm still fighting my deportation. In 2018, they actually arrested me and put me on a plane to Florida. And even though there was a court-ordered stay, as I was sitting in the detention center, they were talking about, we don't give a. Am I allowed to curse, Audrey? Yes. No. Okay. They don't care, right? About what was in the computer system. They were going to deport me. And the reason why they were going to deport me is because I've said clearly who they are and challenging them. In fact, I was, even though I was facing deportation, I was in the rooms with the FODs, the field office directors, and when they found out, wait a minute, I'm in your custody, literally in their custody, and I was challenging them in a meeting face to face. Two things happened. They realized they couldn't lie about it is the immigrant's fault. So you see how powerful it is to have the persons who are living this process be in the room so that they cannot say something without it being challenged. But two, when they heard that, immediately the AFOD said, wait a minute, you're in my custody? Maybe we should take you in now, right? Making a joke. But because I challenged them every day, they knew they had to get rid of me. And in 2018, they did that. They were trying to do that. The reason I'm here is not because of the legal system, right? The reason I'm here is because we had city council members getting arrested. We had officials getting arrested. We had people, we had elderly, we had hundreds of people who were standing there stopping my deportation. And when the court, normally the court, when you file a HABE to stop someone's deportation, immediately something called 1252G comes up, which is the court doesn't have jurisdiction to stop someone's deportation. So why in this case did it happen? Because the community made it public. It was a community strategy that became very public, and the court, the judge herself saw this and was moved to actually give us a positive order. You know, it was really, I wasn't in the courtroom, but the courtroom was packed. We had literally 50, 60 faith leaders and people outside. And, you know, when she actually gave the decision, everyone was crying. In fact, I'm going to get emotional. Everyone was crying, including the police who we normally fight against, right? Because I was part of this community. So when we talk about legal strategies, the thing we need to remember, it is not just about, yes, these are the options we can take to court. And let me address that, because when I talk about immigration, I say as immigration advocates, we are working in quicksand. It feels as if we are working in quicksand because every day something is changing and we don't know what is going to happen tomorrow. And we saw that especially under the last administration, where the Attorney General would refer cases to him that had a precedent set for years, right? I think matter of AB, the asylum case. I'm not a lawyer, I said, so I'm not sure if I'm saying this right. But he took this case because he wanted to issue a decision that would stop other people from benefiting from the previous order. And that happened not only once, but many times. So what is the legal strategy? It could not, we have to understand that because of the way the immigration policy system is written, you can easily have an AG change the decision and change the way it is interpreted. And so that we cannot only look at the legal strategies, we need to look at the community impact. So I'm going to talk about what you can do. And I know many of you are law students, and you're going to the legal field. Claudia said that because of this lawyer who was willing to take the case up and fight for her, not just, okay, we got a decision and I'm sorry, but literally took it to the next level. That is the reason. The other reason I'm here. My lawyers, I'm represented by the New York University Immigrant Rights Clinic. I'm the oldest, not the oldest client. I know I look old. I'm sorry, but I'm only 35. But I have been their client since 2008. 12, 13 years. 13 years, right? And we have gone through so much. We went to the Supreme Court twice. We have gone to obviously the Court of Appeals, etc. And when they took me away, my wife wrote an op-ed, and my lawyers were always very creative and looking for ways to challenge the system. And that is not because they were lawyers, but because I worked closely with them to push them to say, listen, though we need to look at other ways. And we never thought that there would be a way that we could fight based upon the First Amendment. As immigration lawyers, no one, and I'm talking about no one, ACLU, AILA, no one was ever thought that we had a case in court for First Amendment, except a private firm. So why am I in court right now on a First Amendment case? A private firm read the op-ed and immediately thought this is a First Amendment case, and they reached out to us, and they filed a case. Arnold and Porter filed a case in the court, and they asked, well, do we want to apply for a stay of removal? And my lawyers and we always say we do everything. We throw it up against the wall, and hopefully something will stick. We didn't expect it, and we filed it. We applied for it. It was denied. It was denied. But then we appealed it. And in that appeal, I was given a stay, which is still holds today. But it wasn't just about the legal strategy, it was the community that was there present. In fact, whenever they had a hearing, whatever part of the hearing was, we always had community attend those hearings, and usually have two overflow rooms with people who attended. That has an impact on the judge. That has an impact on the system. And we have gotten, that's why I'm here, because because of the community. So what else can the community do? You are the lawyers, the law students, what can you do? There's over 900,000 cases in court right now, right? That's a best case scenario. There's about 300 attorneys, which is, for me, good, because that means the longer they take with cases, the more people will stay here. So I'm not arguing about getting more judges, please. Right? And remember, I actually want to end immigration policy. I'm not talking about open borders. I'm talking about ending immigration policy. If you want to discuss that, you can invite me for another panel. I'll talk about that. So how much lawyers do you need to have to be able to represent everyone? How much lawyers? You will not be able to represent everyone. So what is happening a lot of the times is lawyers are taking easy cases. Oh, this is an easy asylum case. We will win by numbers, but we also have to eat to survive. We also have to get win cases to survive so we can eat also, right? So there's a lot of things you have to address even as you want to challenge the system, but you cannot challenge the system if you're only looking at the easy cases. You need to take a case like Claudia, you need to take a case like mine, but it takes time, it's consuming. And do you have the resources to do that? Most of us don't, but I am looking at the WNE clinics. They should be doing those things. They should be handling those cases. So what else can you do? How do you as a lawyer now shift from saying you need to lead and actually walk with? Claudia talked about, and I'm mentioning Claudia because if Harvey or Ragni had spoken, I would actually talk about I would speak to what they were saying. If you're coming here to save me, don't waste your time. But if you're coming here to work with me, then we are allies, right? What we did as New Sanctuary is we created a new model where we had non-lawyers working with people who are facing deportation, especially especially on the asylum cases. 12 pages long, and you'll hear someone address that in a minute, which is very complicated. That the volunteers or non-lawyers would be trained and actually filling out the application, not providing legal advice, just interviewing the people. What is your name? What were your problems? And my time is running out, so I'm going to just take 30 seconds more, if you don't mind. Let me just finish this thought. So they would just interview and put the information down. Then we would have this is where you come in as lawyers. You will then take that application that non-citizens non-lawyers would work on 2 or 3 hours, and you as a lawyer would take this and review this, interview the person, and in 20 minutes, you have a completed application. 20 minutes. We were doing 250 cases a night. And in addition to that, we had a program called the accompaniment program, which we would partner US citizens and non-citizens to go to court. And when we submitted these applications, the judges, it is actually a pretty beautiful application. It is really completed well. The judges actually started to hold us accountable. If you're doing this, you need to be clear about how you do it properly. Remember, this is pro se, right? All of this is pro se. No one was represented. But I want to end with the accompaniment program where, because we would sit in the courtroom and hold a judge accountable, the immigration judge. We have won cases and the judge have gone in record. So it's not only about how good the judge is, we have shifted judges into becoming more positive because of the accompaniment and because we have been present there. And you can look at a recent victory we got in Shakuri. I can't remember his first name, Shakuri, who was released from detention like 2 weeks ago, even though not only did he have a criminal record, but he had a serious criminal conviction. And normally they will keep him there until they deport him. So it is very important that we work with community and that community becomes part of this discussion, not just about the non-lawyers, but impacted people like myself who are not victims, but we are advocates in our own struggle and our own fight. And I'll pass it back to Claudia. Thank you very much.
Thank you so much, Ravi. What a wonderful presentation, and it's so important to hear some of the things that you presented on today, and thank you for correcting some of the things I said and pushing back on some of the things I said, because that's part of the conversation, right? That's how we work together in the struggle. Our next presenter is Eloa Celadon. She is the principal attorney at Celadon Law in Massachusetts. Attorney Celadon graduated from Assumption College with a Bachelor's of Science in Liberal Studies and holds a JD from Massachusetts School of Law. She represents clients across the United States through consulting and expertise on immigration through family members, asylum, and co-representation, and assists companies with their immigration needs. Attorney Celadon has worked for nonprofit organizations and private entities where their primary work involved issuing issues pertaining to immigration contracts, disability law, and family law. In 2019 and 2020, she was presented with the Rising Star Super Lawyer Award. And in 2020, she was also awarded Top Attorney, Massachusetts Outstanding Young Women's Lawyer. Recently, with the assistance of the ACLU of New Hampshire, she argued before the First Circuit. Welcome, Attorney Celadon.
Well, thank you so much, Claudia, and thank you to Caroline Foley for the invitation. I am truly honored. I'm also honored to be part of this panelist with amazing legal minds and hearts, because in this profession, you need to have both the mind and the heart. If you don't have one or the other, it would not be the place for you. So I thank each of you, regardless if you're an attorney or not, if you're dedicating your time, your passion to do this work. It's really something that I always say to my staff is clients that are deserving representation, when they have this type of care and passion, there's really no money, nothing that could surpass what we're doing. So my topic today is about my experience as a litigator. I wanted to share a little bit about the work I've done. I've also, thankfully, I have Harvey and Sanyu part of this panel because they were co-counsels with me in a more recent decision issued from the First Circuit. And it's an issue that I think most of our immigration lawyers in our community are very thankful for, which assures respondents, non-citizens and detained or non-detained, but are before immigration judges, will have an opportunity, time to seek counsel. So my topic is about meaningful representation. Access to meaningful representation can be a beacon for persons in perilous circumstances. And I want to go back a few years ago where I went to my first detention visit, and actually was my first detained case that I one. But there's a story to it that I'll never forget, and that always pushes me to think about the cases that are coming in. And this is the case where it was really the mark that landscaped the career as the litigator. I went into the facility in Plymouth that day as an eager young attorney. I had my file, I had, my favorite pen with me. I was so happy I had the licensed attorney card, and I checked in, and then I was told to go through the check-in process, which they have guards and they'll check for security purposes. And I had a paper clip attached to my intake inside my file, and the guard said, "Counsel, you have to remove that paper clip." And then my first thought was, well, my client is not a criminal. And I say this because respondents in immigration matters are often treated like criminals, are often looked down, often the first thought to many for those that are not passionate like you and me are, well, they deserve to be detained because they did something wrong, they didn't obey the law. But in most circumstances, there are reasons. In our immigration, as Claudia has pointed out, it's broken, it's dysfunctional. And we have not meaningfully, in the right way, able to really focus on who should be detained and why is this person detained. So before I get to the stories, which I'm so eager to talk about, and as Claudia and Ravi were talking, I started remembering other cases, which I didn't point out. I had submitted an article to the law review. I said, bummer, I should have included this other case because it actually talks about my experience, and it's very similar how community and as attorneys, we have to do more for our clients. But thankfully, I have enough time to share those experiences. But just a little bit of background about the immigration setting. We have to recognize that removal proceedings are civil and not criminal. Non-citizens, face removal. They're often restricted in their rights, their protections of their rights. And unlike criminal defendants, non-citizens have no Sixth Amendment right to government-provided counsel in immigration proceedings. They only have a statutory right to retain counsel. So in other words, if a non-citizen is detained, they would have to seek an attorney of their preference. Unfortunately, that's not the case, and historically, that's not the case in immigration setting. Not like criminal, if you're indigent, if you're unable to retain because you don't have the funds, the state will provide a public counsel. The right to be represented also gives them the protected right under the Due Process Clause of the Fifth Amendment, which applies to all persons. So they do have that right to be represented, regardless if they're looking for temporary or permanent representation. Sadly, in the immigration context, there's no constitutional recognized right for appointed legal representation, as I mentioned. I also like to mention, even in family law settings, in cases there's low cost legal assistance. In our immigration setting, thankfully, we do have pro bono organizations, but as we all know, and I'm sure most of you can attest to this, it is understaffed. The resources are limited. So most of our non-citizens that are detained are unfortunately without access to representation. And I do want to point out not only the importance of representation, but the importance of meaningful representation, adequate, competent lawyers. In our immigration world, we have good lawyers, and we have lawyers out there that are unfortunately in for the business of having a practice of not meaningfully representing clients. The reason why it's important to have meaningful representation, and it's not just putting myself out there as a good lawyer, but it's also because, as Claudia's mentioned, we all have a story to tell. And my story is basically I come from an immigrant family. My parents are from Chile, and I was born in Brazil. So there were immigrants in Brazil. And my father always said to me that it was quite hard to be an immigrant in Brazil because the immigration system was complex. For them to become legal took years of work. And when we settled in the US, we went through another system and another process of immigrating and adjusting our status. We had a wonderful attorney who worked on our case. So I myself can acquaint myself with what it's like to be an immigrant, a non-citizen, what it's really like to go through the hurdles, through the expectations. My mother the other day reminded me how when they were going to their green card interview, the officer did not want to prove the case. And she went to the bathroom as a Christian woman, very devoted Christian woman. She said that she kneeled down and she prayed and she's like, God, do a miracle. And then she came back to the interview and the officer just threw the file down and said, you know what? That's fine, I'm going to prove this case. But it just took so much to approve it. It took tears and also putting yourself out there, like, I deserve this. And that should not be the case. But my story obviously doesn't involve detention, but it does involve about what it's really like to be an immigrant in this country, what it's like to fight for your rights, what it's really like to have a good lawyer. And we had a good lawyer in that case. I also like to point out that the Department of Homeland Security has trial attorneys, which is the assistant chief counsels in all these proceeding cases. The government is represented. Department of Justice also has their own attorneys or advisors. So judges have, attorneys representing their interests, the cases, they do the research. But what is it really like for someone in the immigration setting who doesn't have an attorney? Do they have any fundamental rights? Do they have any due process rights? So I like to point out two cases, possibly three, but the first one is a client of mine who, again, the one I want to go back to, that was one of my very first detained cases. I received a very frantic call from the wife. She was coming to the office as she called, and she said, ICE just picked up my husband. And I immediately thought, oh my God, I'm a new attorney. I did a lot of work, but not for removal cases. But let's see what's happening. I took her into my office. I did the whole intake. And I said to her, I will go visit your husband tonight. I head down to Plymouth. And as I go through the security guards, Plymouth is an interesting facility. It's like a maze. You go through a few sets of floors to get to the facility where the immigration detainees are detained. And sadly, they're all detained in this large space with their cells, but they also share the common area. So as you get into the attorney room, you can look down from a door and there's an open space to it, and you can see them all talking. And that really, really made me sad. I thought to myself, like, should they all be there? I mean, and I thought about this client who is a father, 3 kids at home, a wife who's obviously desperate for an answer. And I looked around the room and I'm studying the room. I'm like, wow, it's nice to be in this room, but not really, actually. It's sad looking. It's a yellow walls. There were 2 desks. There was a desk where the attorney would sit with the client, and there was a desk where there was a desktop. And the desktop keyboard was dusty, so I don't think anyone actually used that computer. And there was a binder, and the binder, interestingly, had prints of INA regulations, and then it had explanations about what is asylum, what is this, but in a way that I would think to myself, if I could only understand this is if I'm fluent in English and I could actually, comprehend the material. But as a lawyer, obviously, you read that and you think, okay, this is understandable. So when my client came in, he was Brazilian, and I sat down with him. I had him answer a couple questions with me, and then he said something that really changed how I would take this case. He told me that the reason why he was detained and not his family was because he had a prior removal order. So what that means, at some point before his second entry to the US or his reentry, he's already been removed from the US. So a year back, he had entered with his youngest son into the US. The CBP officers allowed his entry because he claimed fear, and also because he had a minor with him, which is his son. When they enter, they issue the son what's called a notice to appear, which is almost like a criminal complaint, but it's in the immigration context. It's the charges against that individual. So for the son, immigration had, you are not a US citizen, you're a national of Brazil, you violated this section of the code, which is 212 INA. And then on the bottom, it has the officer who issued the NTA, and it should be someone with authority to sign, and potentially, and not all NTAs, includes your next hearing date. However, my client who was detained was not issued a notice to appear, which would place them in the 240 proceedings, meaning that they would have an opportunity to seek relief before an immigration court. My client instead was issued a reinstatement of a removal order and an order of supervision, which means that once a year or every 6 months, he would have to report to immigration officers upon his release. So when he was released, he was to report once a year. And the day of his reporting, so a year has passed, immigration officers in Burlington office said, you know what, we're going to detain him because he has a reinstatement order, and we're going to put him in detention to execute his removal. So that's where his story is different from the remaining of the family. The family, in other words, we have an opportunity to seek asylum. However, my client, because it was a reinstatement order, and which is really an immigration lawyer's worst nightmare, is we would have to go before the asylum office and pass what's called a reasonable fear interview, which is a much higher standard than when you're seeking a credible fear interview. Credible fear interviews usually are first entries. The standard is lower. A reasonable fear interview, the standard is higher. So you have to really convince the officer that, you know what, if I were to return to the country where I fear persecution, I will die. So please do not let me be removed. Allow me an opportunity to fight my case before an immigration judge. But it gets harder, because if the officer says, okay, I find your testimony to be credible, and I find that, yes, in fact, that I do believe that you're going to be persecuted, now you're only going to fight and withholding case before the judge, which is the higher standard to show a judge as well that you have a fear of returning and that you're more likely than not to suffer persecution, and you have to have a protected ground. So when this client said to me, I do fear, and his only story at the time was, well, I fear because I owe money to loan sharks in Brazil because I had a car wash business and I owe a lot of money. So these loan sharks are after me. They beat me. They went after my family. They attacked my wife. So that's why I'm in fear, but no lawyer would take my case. And I said, yeah, I really don't think you have a good protected ground, especially in our circuit. But then as I started looking at him, and I think this is where the light bulb was like switched in my brain, I started thinking about, okay, protected ground. So they teach us about protected ground, about race, particular social group, religion. So if you fear, you need to have a protected ground for asylum cases. So I looked at him, I realized that he was not a white Caucasian Brazilian. And I said to him, how do you see yourself, your race in Brazil? He said, I'm Black. And I said, okay, all right. So you claim that you fear returning to Brazil because loan sharks owe money, you owe money to loan sharks, and they've attacked you, they've stabbed you, they have attacked your wife because of it. So tell me, have you reported these crimes to the police? Yes. How many times? 3 times. I said, okay, well, if 3 times, and why are you in the US? I mean, why did you decide to come? Well, the police are unwilling to take down a report. They were unwilling to investigate the crime. So I said, you know what? I think now we may have a case. So what was presented to the asylum office, which thankfully he passed, was that he feared returning because the police is ineffective in Brazil. They're unwilling to protect. And this is where the particular social group we were able to add in the race, and that as an Afro-Brazilian male, he has less protections. The asylum office agreed to that argument. And not only did the asylum office agree to the argument, the judge on that case also granted him withholding under CAT, which is the Convention Against Torture. And what really was the highlight of the moment, and this, I say this to future lawyers and to those who are just eager to start this career. I see that some of you are probably going to be taking the bar soon and are just can't wait to start as lawyers, is the judge turned to my client. And this is a client that I truly love, but he was a bit annoying. So he was detained almost for a year. He was the type of client that towards the end wanted to give up on his case. And I could understand the struggle, and I could understand because I visited him at least 10 times throughout those months. And towards the end, he was really kind of giving up because he was tired. He was very worried about his family. The family was struggling financially. But towards the end, I said, just keep pushing. I think in your merits, we're going to have a really good chance, but we got to continue. And at the end, the judge turned to him and said, please look at me. And he said, look at your attorney right now and thank her for the job well done. And that was really the highlight, because I could not have carried through another couple years that were in removal defense. And that always stays in my mind, a job well done. We're not perfect. As attorneys, we struggle. We struggle sometimes with how the system carries itself. We struggle how sometimes clients sometimes won't believe in us, and sometimes are frustrated with our work or with the speed of the work, that we're not getting the results right away. But hearing that from a judge, to me, was really kind of what carries me through and wants me to continue to do the work that I do. Another story that I wanted to share with all of you is the Hernandez case. This case is actually one that you can research on. It's a First Circuit case, and I wanted to also emphasize that Sang-Yu from ACLU, who's also a panelist here today, and Harvey, who's a wonderful mentor, were also part of this case. This case is about a Salvadorian woman who was detained in Stratford, New Hampshire in 2018. She was detained because there was an unfounded allegation that she was part of a gang in El Salvador. So she retained an attorney in Maine because she was originally a resident in Maine who spoke her language. And that attorney, from our research and speaking to that attorney, she's the only attorney in Maine who specializes in removal defense. So Hernandez had hired her for the bond and custody proceedings. She was detained in, as I mentioned, Stratford, New Hampshire. At her bond hearing, and unexpectedly, the attorney was not aware that this was going to be introduced. The government attorney, the trial attorneys for the Department of Homeland Security, introduced that Interpol notice, which the judge didn't much question the notice, but instead just denied her bond. The attorney at the time was not taking removal cases because in immigration court, an attorney can decide either to represent a client in all proceedings or just a bond in custody only. So she said to Hernandez, unfortunately, this is all I can do for you, but now you're pretty much, you're going to have to find another attorney. Hernandez, just to give you a little background, she completed up to 3rd grade El Salvador. She comes from a very poor family, single mom. Mother was a single mother with, in one of the kids, obviously an adult child, was involved with gang activity. And that's where the Interpol notice was placed against Hernandez. Hernandez had never, ever been part of the gang. She's never done anything for them. Instead, while she was in El Salvador prior to her entry in the US, the gangs were after her because they weren't able to have access to her brother, who at the time was detained in El Salvador. So that's those unfounded allegations that she was part of a gang with no underlying facts that would support that claim. Hernandez was detained for that reason and lost her bond custody hearing for those reasons. I received a call from Hernandez a few weeks after her bond hearing that she needed representation, and her representation required me to show up the next, almost a few days after, before an immigration judge. The judge denied more continuances in her case, and we weren't able to appear before the immigration judge because he would not allow more time for her to have a new attorney, even though the Department of Homeland Security agreed to another week. This case, I came in as the appellate attorney, where we lost. The board agree on that case. And then I get a call from Saintsir. You guys can tell me how many minutes I have left, but I get a...
I actually, yeah.
Okay, so just to resume, I get a call from Saintsir, and he says, why don't we take this case to the First Circuit? And I said, Saintsir, I've already lost a case in the First Circuit, so I'm really afraid to do that. But thankfully, he encouraged me. We got Harvey on it. And I hope you guys get to read the article. It talks a lot about how meaningful representation, how Judge Lipez, who issued the decision, really pressed hard that this is definitely a fundamental right. So thank you so much. Thank you for the opportunity.
Thank you, Attorney Celadon. I know there's so much to share. It's so hard to keep it confined to our time limits, but luckily we have Attorney Kaplan next, Professor Kaplan next. So he'll get to hopefully continue on with your, with this case and share a little bit more about it so we could get a bit of a fuller picture. So Harvey Kaplan is an immigration attorney and professor emeritus at Northeastern University School of Law. Attorney Kaplan received his undergraduate degree from Clark University and his JD from Boston University. He was an immigration practitioner for over 35 years and the founding member of the immigration law firm Kaplan, O'Sullivan, and Friedman. He specialized in immigration appellate work in federal court. He has been the recipient of numerous national awards. Most recently, he received the 2018 Humanitarian Rights Award from the Open Avenues Foundation. Attorney Kaplan taught in immigration law course at Northeastern University School of Law for 25 years. And after retiring from private practice in 2014, he began volunteering in the immigration law unit of Greater Boston Legal Services. As an Access to Justice Fellow, Attorney Kaplan continues to volunteer work with Greater Boston Legal Services. So welcome, Attorney Kaplan.
Thank you. Can you hear me? Hello?
We can
Hello?
hear you.
We can hear you.
You can hear me, thank you. Good morning, everybody. You imagine the following. You're in private practice and you go to the office to complete a very simple case, a relatively simple case, an adjustment of status case based on a marriage to a US citizen. You don't expect to be there that long. And you get like a Loa, you get a frantic call from a man who says, my wife, mi esposo, was detained by immigration and we have a US citizen child and I don't know what to do, can you help us? So you say, as a good private practice attorney, I need a retainer of $1,500. And he says, I don't have the money, but I'll try to get it someday. So you had arranged with your wife that after you finished your limited work, that she would come by with the children and you go to visit a zoo. So now you have a choice. Should I go to the zoo or should I take this case? And the following transpires. And so you visit her in detention, and she tells me her story. She says she's from El Salvador. She entered the country without inspection. And 3 nights ago, someone knocked on her door at about 10:30 at night. She asked, who is it? And the person said, police. She said, I didn't call the police. The person says, police, we need to talk to you. She will not open the door. There's a chain link on the door, and they bust through, and 3 men enter, all in plain clothes. They do not show a warrant, and they do not show any identification. It's also intense because there's a high incidence of so-called illegal aliens in the neighborhood. He says he's looking for Juan Gonzalez. Juan Gonzalez is a boyfriend of one of the other women that live in the apartment. She says that Juan Gonzalez does not live here. They immediately go into the bedrooms of all 3 women and ransack the place and discover that the other 2 women have temporary protected status from El Salvador, which allows them to remain in the United States. Your client, this woman, does not qualify for this status. The man insists, where are your papers? She says, she says, I want to talk to a lawyer first. And the person says, you can talk to a lawyer after we're through with you. And a lawyer will not help you. And if you do not cooperate with us, we will recommend to the immigration judge that you be deported. She's 5 months pregnant. She's worried about her child at home. She has high blood pressure and needs some medication. They take her down to the immigration, and she signs a statement admitting to removability and that she is here illegally in the United States. The statement contains Miranda warnings, but Miranda warnings are not the warnings that need to be given when someone's arrested. So it's misinformation. All of this is important because we had to show that there was violations of the regulations, there was coercion. What was this woman to think? If I don't cooperate, what's going to happen to my child? So she finds a statement admitting she's from El Salvador, and she's also afraid that somehow she'll lose custody of her child, and the welfare department would be notified. You evaluate her case, and unlike a Lowe's client, she does not really have a claim for political asylum. So you decide the only type of relief that you can apply for is voluntary departure. The only other choice is to file a motion to suppress. The ups and downs of that is that while the case is litigated, there's a chance that you'll be detained throughout the litigation, and there may be various appeals to the Board of Immigration Appeals and to the First Circuit Court of Appeals, where you will be able to obtain a stay of removal. So we go to the hearing. You go to the hearing, and you fill out the pleadings, and she refuses to admit her name. The immigration judge is perplexed. Says, if she does not admit her name, I'm going to order her deported. You state that she should not have to admit her name because there's a criminal offense to enter without inspection, and the government should have the burden of proof by clear and convincing evidence as to each and all the allegations in the notice to cause. The judge says, no, I'm going to order deported, and under these circumstances, she does admit her name and admits that she came into the country without inspection. The judge finds her that the government has met the burden of proof by clear and convincing evidence that she's removable and here in the United States without permission. So now we come to the hearing, and you have now advised her not to admit her name at the hearing. So the judge again is perplexed. He says, if you don't admit your name, I'm going to order you deported. So under these circumstances, she feels coerced or feels that she has to admit her name. We're going to preserve that issue for appeal, saying that should not have been considered as part of the case. And the government proceeds to introduce their evidence. They introduced an I-213, which is a record of removable alien not signed by the client. They introduced her signed statement admitting removability. And they introduced a certificate of non-existence of record in the agency to indicate there is no record of her ever entering the country legally whatsoever. And how did she get here? She must have come in entry without inspection. Judge also rules that allows all that into evidence and orders her deported. Now you're dealing with the motion to suppress. The bad news or the difficult news is the Supreme Court, prior to this Supreme Court, has allowed cases to be denied where the violation was only was in good faith or there was a technical violation. So since we're modeling a lot of our motion to suppress on the criminal analysis of the motion to suppress, this is not, it can't be optimistic if this case ever reaches the Supreme Court on the violation of the Fourth Amendment, which is the issue is, does the mere violation of the Fourth Amendment merit suppression of the evidence? So you reserve the case for appeal. At the end of the hearing, your government throws up in court. The judge immediately yells at you and says, this is your fault, implying that you've raised these issues, made it go through this tortuous hearing, and that your tactics are dilatory and frivolous. Don't worry, you know that representing your client to the fullest and raising constitutional issues means that you are doing your job. Now let's take a look at the case law. And there are two cases that I would advise you to read, which I'll summarize quickly. One is Novia Duran, 568, F. 2nd, 803, First Circuit, 1977. And the other is INS v. Lopez Mendoza, 468, US 1032, Supreme Court, 1984. Now, motions to suppress are not in the Constitution. It's a court-created process to vindicate people's rights to a remedy when there is a violation of the Fourth Amendment. The case goes to the Supreme Court, and Justice O'Connor, 1984, rules that a mere violation of the Fourth Amendment does not support the motion to suppress. Now, what's interesting is there was a 5-4 decision in 1984. Just to think that we're that close to getting a favorable ruling on that issue. And unfortunately, once again, the present Supreme Court will probably not be too receptive to some of these issues. But what was the rationale by Judge O'Connor, with a strong dissent from Judge Brennan, was that deportation proceedings are supposed to be simple. Now, where did she get that? You have issues of life and death. And why should those due process rights and general rights be simple? It doesn't seem to make sense. He also says, it's in a motion to suppress in a criminal case, even if you're successful, let's say drugs were involved, the drugs would not be returned to society. In this case, this client would be returned to society, somehow comparing a so-called undocumented worker to someone who deals with drugs. She also implies that how would an immigration judge understand Fourth Amendment law? It's too complex. It's going to be too difficult. The INS agent or the immigration agent is not going to remember what happened, especially if there was a raid. Now, who understands immigration law? You know who understands it? the agency itself. They have a disciplinary board. And so if there's a violation of the Fourth Amendment, you can take it to the disciplinary board. Well, the disciplinary board is certainly not impartial. In order to decide a motion to suppress, you need someone who's impartial and someone who understands Fourth Amendment law. So she rules that there's too high a cost to society to allow a motion to suppress when in removal proceedings, which is then called deportation proceedings. And sort of imply, so now there's a case of Navia Duran. Now, Navia Duran is fairly similar to the facts that we laid out previously. There was refused to sign a so-called confession on the advice of her lawyer. Her lawyer was called an idiot by the INS agent. You can read that right in F2nd, I think. So if he was, that agent was willing to intimidate a lawyer, what intimidation factor would there be when she was arrested in her apartment at 10:30 at night? So the judge, this case was very fortunate because there was a visiting judge, Judge Tuttle, who was a judge from the Fifth Circuit, who was extremely well-known on prisoners' rights, and he wrote a great decision and basically said, we're not necessarily going to reach the issue of whether Fourth Amendment violations justifies the motion to suppress, but since there were so many other violations, the failure to read her rights correctly, indicating that she had no choice but to sign the document, indicating that they were going to recommend to the judge she be deported, this sort of turns into a Fifth Amendment violation, which means that evidence should not be used where it's fundamentally unfair. So we still have the case law that says that a mere violation is not sufficient, but we do have the case law that says an egregious violation of the Fourth Amendment. So you would have a strong case to argue this is a Fifth Amendment violation. They knocked on the door, they entered without a warrant, there was no emergency, etc. So where does this leave you? It might leave you angry with that your spouse and children are angry with you. These are some of the risks that you have to take as an immigration lawyer. Take the risk that an immigration judge is going to yell at you. But after you do this case, other lawyers call you up because you're now considered an expert. Sometimes in law, in an immigration law, if you do a complicated case, people believe that you're an expert, and that's how expertise sometimes evolves. Now the problem is that your client is detained. So if you have to go through this series of appeals of the removal hearing, it may not be such a benefit to your client because she doesn't want to be retained for potentially a long period of time. So now, what do you do and what do I do? Usually in cases like this, I turn to Sanyu Boumediene, and they're going to tell you some of the alternatives. So go get them. I want to also mention that when I first practiced immigration law, almost 50 years ago as a student, starting as a student, that immigration lawyers were considered like insurance agents. What do you do? You fill out papers, simple. Now we have reached the status, a recognized status, because of the incredible litigation that has been brought by various agencies. Again, once the ACLU, Greater Boston Legal Services, too many agencies, yard agencies, have raised the level of practice from being a mere insurance agent to be a recognized creative lawyer. Thank you.
Thank you so much, Attorney Kaplan. It's so nice to hear a little bit more of the work you've been doing. Up next, we have two panelists. We have Sing Yup Kim, Immigration Staff Attorney at ACLU New Hampshire, and Ragini Shah, Immigration Clinical Professor of Law at Suffolk Law University. Attorney Kim is an immigration staff attorney at the ACLU of New Hampshire, and he has gained extensive experience in detention and removal defense in New Jersey and New Hampshire, providing pro bono consultation and legal representation to detained immigrants. Professor Shah is a professor at the Law of Suffolk University, and she has done a lot of work, extensive research combined with working at the border, and her scholarship examines the effectiveness of enforcement in the immigration context, focusing on rights for undocumented youth and the connections between international trade and migration. So we're so happy to have them both, and welcome Attorney Kim and Professor Shah.
Thank you so much, Claudia. And I just want to thank everybody at Western New England for having us as part of this symposium. It's really an honor to be on this panel with so many distinguished warriors for immigrant justice. You know, Harvey was actually my professor, immigration professor, when I was in law school. So it's fantastic to be on a panel with him. I'm just meeting Aloha for the first time today, but really interesting to hear her work. And of course, I've followed Ravi Rugbir, your case, for many years now, and you know, your work with New Sanctuary Coalition. But I just did want to say that I teach that your First Amendment case to law students in order to help them see not just the excesses of the immigration system, but also what creative lawyering can do. So it's really just an honor to be here with everybody. So Sangyob and I are going to talk about the availability of habeas relief. And a lot of you may think about habeas corpus, right? Like, which literally means produce the body, as being something that people use to get people out of detention. And it is that, it's absolutely that. And that is a very important use of it. But also you have to think about, well, what is detention for in the immigration context, right? And detention in the immigration context is not a punishment. It is primarily in order to effectively deport somebody. So deportation is actually the official goal of detention, right? That's what the government is moving towards, is deportation. So habeas has also provided a really important strategy for non-citizens to challenge the government's ability to deport them, right? Not just to detain them, but also to deport them. So you could think about this in terms of like the literal meaning of habeas, right? As being about your body. So this is about not just jailing your body, but also forcing your body onto a plane or a boat, or, you know, whatever the mode of transportation it is. And I think Ravi sort of alluded to this in his own case where they filed a habeas, but there are a number of non-citizens who filed habeas claims in order to stop the government from deporting them in some sort of arbitrary way, or if the law itself leaves a gap, meaning that a person can't even get to the end of their case a lot of times under the current state of the immigration law before the government has the ability to remove them from the country. So we're going to get into those details. And so there are a couple of things I just wanted to set up in terms of framing our conversation. The first thing is that the reason we're talking about the availability of habeas is because of this Supreme Court decision that came down last summer called Department of Homeland Security versus Thursigian. This is a case that Sangyob is going to talk about in more detail, but the bottom line is that that case may have really limited a non-citizen's ability to access habeas for anything except for these detention-related claims. Our argument actually is that it's not limiting and that people should still use it. And we're really hoping today to be able to impart some information to lawyers, to law students, to be able to continue to use habeas as a really important way of challenging the government's deportation. A couple of other things I'll just very quickly say before I hand it over to Sangyob. One is that habeas corpus, for those of you who are law students and may not have read a lot about it, is something that predates the US Constitution, right? The concept comes from English law that predates the US ratifying its constitution in 1789. So we've imported that concept, and habeas corpus appears in the constitutional text itself, not in the Bill of Rights. So it's something that was so important to the founders that it's actually in Article 1 of the Constitution. So that's something that's just important for us to kind of make sure that we remember that this is something that's available. And also, habeas has been used by non-citizens to stop deportation since that founding. Since the 1700s, there have been non-citizens who have brought habeas claims and have essentially argued that the government should not be able to forcefully remove them to another country. And they've succeeded, right? The Supreme Court has said, yes, you do have a right to file a habeas for that purpose. So thursigium kind of comes up in that context. And with that, I'll hand it over to, oh, actually, let me just outline what we're going to talk about. So we will talk about the thursigium decision. Then I'm going to come back and talk a little bit about how thursigium changes the state of the law from what it was before. And then each of us, Sangyob and I, are both going to describe situations where we feel like habeas is still available, really as a launching pad to help people start thinking about how we might be continuing to use it. So let me hand it over to Sangyob to talk about the thursigium case.
Great. Thank you, Ragini. So before I talk about thursigium very quickly, I listened Ravi's story and, his argument. I kind of thought that, the difference between DACA case in the Supreme Court and thursigium. So DACA was decided on June 18, 2020. And I was actually very surprised that, Supreme Court actually found in our favor. And then 7 days later, thursigium came. So, the difference is it's not just about the lawyers. And, I don't think, Supreme Court found in our favor in DACA only because lawyers were so great. Like, obviously lawyers did their job. But like, what is the factor that was absent from thursigium, but that existed for DACA was like community power. So, after seeing DACA, I kind of thought that I became very pessimistic about thursigium, even prior to the ruling. So when I saw the decision that, denying, thursigium's right to relief, I wasn't surprised. But when I actually read the decision for the reasoning, I thought that this case could doom a lot of cases that we already have and we will have. And here's why. So thursigium is all about right to go to court. It makes sense that we all think about that, like, if there's an issue, then we should go to court. Like we go to immigration judge, we go to BIA, but at the end of the day, if nothing works, we have to go to federal court. So that's the basic concept that we all think about. So thursigium, our national office, tackled that issue. So it's about the expedited remover, the person who was detained at or near the border and went through the credible fear interview and was found credible, but not good enough for asylum process. So asylum officer said, I'm not gonna, it's a negative. Under the statute and regulation, Mr. thursigium asked for the immigration judge to review it, affirm. But the law says, there's no access to court. That's the end of the process. The problem is, Mr. thursigium argued that, there are so many legal issues that asylum officer did not properly address. So there's a legal issue that we have to tackle, and without having access to the federal court, there's no way to fix that problem. So Mr. thursigium lost at the district court because the statute actually says no judicial review, including habeas corpus. Thursigium won at the 9th Circuit. It's kind of groundbreaking decision, and then government appealed that decision to the Supreme Court. And Supreme Court, it appears it's a 7-2, but when it comes to the availability of habeas corpus for the purpose of challenging government's deportation, I think it's more like 5-4. So it has two big points. Number one, yeah, habeas corpus has existed since even predates the Constitution, but it has to be limited to pure detention and release claim. So that's what Justice Alito mentions. Like no matter how great arguments you are bringing in this court, like doesn't matter, because what you're asking for the court to do is not about getting released from detention, but it's about stopping deportation, asking the court to review the agency's decision on credible fear interview. That's not something related to pure detention release context. But as like Ragini said, Professor Shah said, the purpose of detention is deportation. So like you are sort of like almost like playing the difference between detention versus deportation, and like foreclosing the entire case. The second part is the due process. The Supreme Court did not have to do it, but the majority did. So the majority did. A person like Mr. Thrasigiyam, who was detained a few feet from the border, doesn't really have sufficient due process right to go to federal court. So that's doomed as well. Now the issue is, it's an as applied case. So it has to be limited to Mr. Thrasigiyam's circumstance. But the way the majority and Justice Alito wrote the decision appears to be applicable to all other habeas corpus, including like Ravi's case, where the challenge is not about pure detention release matter, but it's about the challenging government's decision to deport. We don't really know how this case could affect so many other cases, but it will definitely be a big obstacle that like litigators have to overcome. And for that, Thrasigiyam sort of did not overturn, but de facto overturn like so many other important cases that were existed until Thrasigiyam. And that's what Professor Shah will talk about.
Thank you, Sang-Yob. Yeah, so I'm going to start actually with the case that Thrasigiyam relied on, and then kind of talk about the cases that, as Sang-Yob just mentioned, the Justice Alito tried to sideline, essentially. So the decision in Thrasigiyam really relied on a precedent called Munaf versus Garan, and that's a case from 2008, which is in the military context. So it's very different from the immigration context. It's a case that involves 2 US citizens who were charged with committing crimes in Iraq as part of the armed conflict that the US is engaged in Iraq, or was engaged in Iraq. And the issue was that the 2 US citizens did not want to be transferred into Iraqi custody to face these criminal charges before an Iraqi criminal tribunal. So they brought habeas claims in the United States, even though they were held in Iraq, and said that they wanted the US government to essentially stop their transfer. Justice Roberts, who wrote that decision, said, yes, you're in US custody, so you do have a right to habeas. However, all we can do is simply release you, right? We cannot stop the transfer to Iraqi criminal custody. This is a military context. This is very political. And we're not going to sort of interfere with the military's doings in Iraq. So that case then, Justice Alito decides that case means that habeas is only available to ask for release from detention, as opposed to any other kind of relief that you might ask for. And in the process of saying, okay, Munaf is the precedent that I'm going to pick to use for my holding, Justice Alito sidelines 2 very important decisions that had been applied to non-citizens before that. The first one is a case called INS versus Saintsir. And this is a case that came up after the changes to the immigration laws in 1996. And the new laws in 1996 really created 2 main problems for Enrico Saintsir. The first one was that Mr. Saintsir was a permanent resident of the United States, but he had been convicted of a crime, going back to what Ravi mentioned about how, people who have been convicted of crimes in the immigration system, I mean, this is where the fight is, right? Because there's always an easy ability for Congress to take rights away from those folks. So Mr. Saintsir had been convicted of a crime. Congress had decided in 1996 that people in Mr. Saintsir's position would no longer have access to relief from deportation, meaning a way to remain in the US. So that was his first problem. His second problem was that Congress also at the same time took away his ability to go to a federal court to challenge, whatever decision is made at the immigration court level. So Saintsir goes to court on a habeas and challenges both of these things, right? His inability to go to court, as well as Congress's ability to take away the relief from deportation that he would have had access to before. And he wins on both of those claims. So basically what Saintsir says, and what immigration lawyers have used Saintsir for years to argue, is that there is an ability for a non-citizen to use habeas to reach challenges to the government's ability to remove you from the United States, right? So Saintsir says very clearly that habeas is available to challenge deportation. So Justice Alito, you'll have to read the article or the decision itself to kind of see the myriad ways in which he just like obfuscates that decision. But basically, without overruling Saintsir, he says, Saintsir is just kind of like limited to its facts, and we don't have to use that decision. The other decision that Justice Alito really sidelines is a case called Boumediene versus Bush. And that case is not an immigration case, it's a Guantanamo detainee who brought that case. But the basic principle that comes out of that case is that even if Congress suspends habeas legitimately, like even if they explicitly suspend habeas, which by the way, Congress has done, right? So after Saintsir, Congress's reaction was in 2005 to explicitly say in the statute, okay, we're taking habeas away. Because one of the issues in Saintsir was that Congress wasn't explicit about their decision to take away habeas relief. And so now the statute says all over it, there's no habeas, there's no habeas, there's no habeas. They want it to be very clear. But Boumediene says, okay, even if Congress wants to do that, if they want to take habeas away, there has to be an adequate and effective alternative available to the non-citizen or whoever in order for that suspension of habeas to be legitimate. So that adequate and effective alternative is another tool that lawyers use, and something that Justice Alito just kind of ignored because he decided in the first instance that there's no jurisdiction to deal with habeas. So that's kind of the situation that Sangyob and I found ourselves in when we litigated the cases that we had. The two cases that we litigated were litigated before Thursigium, so we're going to talk a little bit about those. But we both feel like these kinds of claims should still be available even after Thursigium because of these earlier decisions, right? So I'm going to pass it to Sangyob to talk about one of the cases, and I'll quickly talk about the second case, and then we'll end.
Great. So let me start with this. So Thursigium, Justice Alito mentioned that the court assumes that habeas corpus availability as it existed in 1789. So we are talking about when the Constitution was created. Now, what's important is at that time, there was no deportation. The first ever deportation law came in 1798, about 10 years after the creation of Constitution. That was even targeted to specific people that could be considered as dangerous to the national security. So we're talking about the time that existed when there was no deportation system at all. And we are talking about 2021, where there's DHS after 9/11, and so many ICE officers and have so much power to deport. So that's one very important point that I want to start, because the Constitution could have developed when it comes to the scope of the habeas corpus relief. Now, the first scenario that I think, despite Thursigium, that we can still use habeas corpus to stop deportation is illegal deportation. So what I mean by illegal deportation is, I actually have represented 2 clients for that, and I have confirmed so many cases of this category. So where the law does not allow ICE to deport people, non-citizens, but they are just still doing it. an example could be the BIA already stayed deportation. ICE is just not complying with the BIA's order. The person's deportation was stayed by the federal court, and just ICE is not complying with it, whether that's mistaken or whether that's intentional, regardless. Another example could be when a person files a motion to reopen in absentia, then law actually says that deportation is automatically stayed while the immigration judge is taking a look at it. But ICE, just deporting the person. That's very obvious that it is contrary to the law, that they don't have such authority to deport, but they are still doing it. So what other ways that we can fight? Habeas corpus might be the only way to fight. We don't have time. The person is detained. So we just have no choice other than filing habeas corpus. So one argument that we can make is, number one, we get that Justice Alito's point. When Constitution was created in 1789, maybe habeas corpus was all about just release and detention. Because at that time, for example, if the person shows up at the Boston Harbor and there was really no law about admission, so the only way the person can become a resident in the United States, get out from the ship, right? So person filing habeas corpus just to get out from the ship, and then person just becomes a resident or a citizen of the United States. So we didn't really have to go through all the deportation process. But that's not the case anymore. Now we have to go through this very lengthy, complex process where the agency makes an illegal decision. So even if we assume that in 1789, habeas corpus was just limited to detention and release, in 2020, we have to employ the habeas corpus to challenge the illegal deportation, because I am pretty sure Constitution did not mean to foreclose habeas corpus even when the government is violating the law created by Constitution or Congress. So I think we can make those arguments under suspension clause, that suspension clause still available despite Thrasigya because it's 2021. Now, second argument is statutory argument. So we get that Congress said no review of the government's decision to deport under Section 1252. But did really Congress mean to include illegal deportation? Did really Congress actually include it that even though government is violating the law created by Congress, that's still covered within the jurisdiction stripping clause? And we can argue that it is not. And there are actually very interesting and compelling case laws from early 1900 cases from the Supreme Court saying, if the government violates the law, and if the person is injured by that violation, then courts usually have jurisdiction over the claims. So we may have very compelling claim. But even if the deportation itself is not direct in conflict with statute or regulation, there is another scenario that we think that habeas corpus is still available. And that's what Professor Shah will talk about.
Thank you so much, Sang-Yob. And so the case I'm going to talk about, the procedural history is very complex. So just for the sake of time, I'm not going to go through all of it. But suffice it to say that our client was in a position where he faced torture if he was to go back to Haiti. That's the argument that we made to the immigration court, that he should be able to remain in the United States because he faced torture if he were sent back. One of the reasons that the only argument that was available to us was this torture claim is because our client had convictions which under the immigration laws are considered aggravated felonies. And aggravated felonies is a whole area of law. They don't have to be felonies. They don't have to be aggravated. But hopefully somebody talked about this yesterday. But basically, that's why our client was in the position that he was in, with a very limited ability to argue to remain in the US. The client was also in a position where every set of decision makers had denied his claim, right? All the way up to the First Circuit. We then found new evidence that would really help with one of the problems with the torture claim. And we filed what's called a motion to reopen. So here's where the client's problem starts in terms of ability to adjudicate the case inside the United States, right? So I guess the kind of case I'm talking about right now is one where the clients, because of the way the law operates, they are not guaranteed to be able to remain in the United States while an administrative body looks into what their claim is. And here I just want to say that Sangyob and the ACLU were so incredibly helpful with these arguments and with getting this case in front of the court. And they're just really an amazing resource and agency and have amazing energy for these claims. So I really want to thank Sangyob, because without Sangyob, I don't think we would have been making all of these arguments. So essentially, like I said, our client was in the position where we filed a motion to reopen because of the new evidence that we had discovered. And in this kind of place where you're filing a motion to reopen, there is no automatic ability to remain in the United States, right? You can ask to remain, but they're not necessarily going to give you that ability. So what could happen is our client could have been deported before the agency actually even looked at the new evidence that we were trying to submit. And in our case, it was particularly egregious because the client faced real harm if he were deported to Haiti. And so he wouldn't really have the ability to continue to litigate his case from Haiti. So in this context, this district court judge in New Hampshire said, one, yes, you have the right to file a habeas, even though the law specifically takes habeas jurisdiction away from me in cases like this because your client has a criminal conviction, right? That's that 1252 law that Ravi talked about right at the very beginning, right? So even though this law says no habeas, yes, I do have habeas jurisdiction. Also, I'm going to use that habeas jurisdiction to temporarily put a stop to this client's deportation, because if I don't, then he may not ever be able to fully litigate the claims that Congress seems to want him to be able to litigate. And so in that situation, I would say that habeas is still available even after Thursigium. And if I were arguing the case now after Thursigium, I'll just spend my last minute talking about that. If I were arguing this case now after Thursigium, I think the couple of things that I would do is, one, I would distinguish the client's situation legally from the situation in Thursigium. It's unfortunate that lawyers get put in these positions where we have to do these things, because I would argue that people like Mr. Thursigium should actually have the benefit of habeas. But because we have the Supreme Court decision to deal with, what I would probably do now is say, our client is not at the border seeking admission. He's somebody who's been in the United States for years and years, and he's somebody who is trying to go through the system of seeking relief, but the law itself creates a gap in his ability to continue to litigate his claim from inside the US, right? So I would legally distinguish it. And then secondly, I would factually distinguish it basically in the same way by saying, Thursigium is really only for cases where the person has literally just entered, and it should not be used to reach cases where the person has been in the United States, whether in its status or not, for years and years, and has family ties and all of that, right? So these are just a few of the ways I think that you can still try to bring habeas claims for clients who are facing the kind of arbitrariness of government removal decisions. And we hope that this kind of spurs you to think about more ways of doing that. And thank you again for your time and your patience. I know we're way over time, but thank you for listening.
Thank you both, Attorney Kim and Professor Shaw, on some of the work you're doing as well. I do want to remind participants to, if you haven't sent questions to the chat, to please do so if you want questions answered. And for those of you who have sent questions to the chat, some of them have been answered already via typed answers. So please take a look at that to get more information. We're going to close out this section of the panel by asking each of the participants to share just very briefly a call to action to attendees and something we could do today as we sort of navigate the world beyond the symposium today. So we'll start with you, Ravi. Do you have any
Yes, I still have a lot to talk about, but I'm not going to take much more time. What I just wanted to, Torresigium is made such a big impact, including in my case, right? The Supreme Court said there is a violation of First Amendment, but does the court have jurisdiction? So they sent it back down to the circuit, and we are now in the process of distinguishing that. But you know what's bizarre is, and ICE does this all the time. Whenever there's a good decision, they try to moot those decisions out. So in my Second Circuit decision that was sent up to the Supreme Court, we actually cracked the door on 1252G. So there is a way to challenge the 1252G. And AADC, which is the Arab American defamation case. You all have been working on those cases for 15 years, right? And this particular decision was very important because it cracked that door open. But now they want to moot all of that. They're saying they filed a decision, a brief saying, but Ravi is not facing imminent deportation, so the case needs to be mooted out. Anyhow, this brings up to what we need to talk about. You all are hearing that ICE is basically an agency that has no checks and balances. You're hearing the court doesn't have jurisdiction because of what Congress wrote, especially in response to Saintsir, and also I think after the Real ID Act, where they took away even more civil rights from us. But also Congress themselves doesn't seem to have any jurisdiction over them. And you would think that the executive arm, which it falls under, would have the authority to manage this agency. But what have we seen in the last few weeks? Even though there's a moratorium, which is from the Biden administration, the administration is saying stop deportation. But but the agency itself is not even, what's the word? It is not even following orders. They are doing their own thing. So who is actually in charge of this agency? And I want you all to look up plenary power. We know this agency has plenary power, which means technically they can work outside the Constitution, which as lawyers, you should be freaked out about, because as plenary agents, Congress doesn't have authority, the court doesn't have authority, and we are seeing how the executive arm cannot tell them what to do. What is this agency for? They have the largest budget in this type of agency. There is the largest budget, and if you look at the arms and ammunition cache that they have, it is extremely high. I think it's 22,000 bullets per agent, right? So why I bring that up is we need to start highlighting this agency, and not just about highlighting it to talk about how bad things are, but we need to give concrete steps on what we need to see happen. First, I would say abolish the agency, but that may or may not take time. I always say I'm focused on abolishing the agency. You all need to, whoever needs to be coming in, they will be the compromising, but I have to hold a line on that premise. And we cannot come at this from an immigration only issue. This is not only an immigration issue. This is a constitutional issue. This is a racism issue. This is a mass incarceration issue. So we should not be talking about this as only immigration lawyers addressing this problem. We are going to lose. We are losing, right? And right now we have a sympathetic administration. You all know what happens to the Democrats after they get pushed back 1 or 2 times, they suddenly fold. So that sympathy is not going to be there for long. I'm being a realist. I hope I'm wrong. I was wrong when I thought the Biden administration would not address the deportations or the MPP or the reunification. I was wrong. I hope I continue to be wrong, but I have not seen the Democrats haven't proven their worth yet. So what we need to do is we need to come together. And this is my action step. We need to come together as community, as lawyers, as activists, as mass incarceration, as detention, as budgeting, fiscal responsibility. We have to come together. We have to talk, because when we start seeing our intersectionality and start seeing how closely we are, that until we are working together, they will use the fight. They will use us against each other. And when we do that, we are much stronger, and we will be able to change what is happening for not only the immigrant advocate community, but for everyone else. And coming together means having these discussions, listening, talking, but I want to press our communities that there is no one person who has the answer. No one lawyer, no one activist, no one has the answer. So unless we can speak to each other with respect and no judgment, which is the principles of New Sanctuary, we believe no one should be judged, and we should have respect for each other so that we can listen, learn, and move forward together as a community. That we, that we can make change. Lastly, specific steps. You're talking about accompaniments. You're talking about pro se, building pro se clinics. You're talking about ways you can create safe spaces. We talk about sanctuary. All those things are temporary solutions until we get proper change. So I pass it back to you, Claudia. Thank you.
Thank you. That was a great call to action, many calls to action. We have maybe time for one other panelist, if any other panelist wants to leave folks with a call to action or share some final thoughts.
I can briefly just
Sorry, go ahead.
Oh, go ahead. Thank you, Sayub. I would say reach out to removal defense immigration practices. That's something my colleagues and I are like, oh God, I wish, law students or future lawyers could just reach out. Some of us do offer paid internships if you want credit or just the experience, because we're always looking for creating good law, right? So it requires research and writing, and if that's something you're interested, I would definitely, because the nonprofits also have that need, but as removal defense practices, it moves such a quick pace as well, and having that eager soul to help would be a tremendous help. So that would be my call to action. Thank you.
Thank you, Attorney Celadon. Attorney Kim, did you want to add something?
Yeah, just very quickly. I'm just gonna copy what Harvey said and Eloa said. Take difficult cases. There are so many ways to change the legal landscape. You can ask Biden administration to, create new regulation, change the regulation, or you can ask the Congress to create, new immigration law. But one way that you can do it is create good precedent by taking the cases to the federal court. And how do you do it? And the court will not create a sweeping decision. So like by winning one by one, you would actually add something positive more and more. And how do you do it? You have to challenge those decisions. Now, I understand not everyone is a big fan of federal court. I totally understand. So one thing that you can do to lawyer is raise good arguments below. That's the only way to exhaust the jurisdiction requirement. And then if you are not, if you fear that, you don't want to do it, you don't have resources, if the client is not be able to pay, you can, refer the case to other people. But without raising those issues below, there's no issue at the federal court. So I just want to mention that.
Great. Well, thank you everybody for all of your really important calls to actions and reminders to what folks can do as we continue in this work. If other panelists want to add final thoughts, you can please do so in the chat to all panelists. In the interest of time, we're going to take a very, very short break, and we'll come back around 12:09 so we can get started right on time. We have our amazing keynote speaker, Professor Hernandez. So please come back in a few minutes as we introduce him and we hear his keynote remarks. Thank you.
Hi there, can you hear me? I can't see my picture anymore.
I can hear you.
Oh, there I am.
I
Okay.
can see your picture. Yeah.
Yeah, I couldn't respond to anybody because there were no private chat possibilities on the chat I see. But someone just asked me about starting 10 minutes later, and that's fine. So I'll be back in just a second. But if you could tell the organizers, I pronounce my name David, my first name.
Oh,
That's all.
yes. I apologize about that.
Hey, no worries. It's the same name. I don't think anyone said it wrong.
Well,
Just in case.
Claudia, I think maybe she's the one that's moderating. Hopefully she heard that. I'll text her though.
I was gonna write her, but I couldn't.
And thank you all to the other.
Yeah, it was a
Oh
great.
yeah,
panel.
I'll see if she. It was a wonderful panel. Thank you all for being here. It's going great.
Great, I'll be back.
Hello, everybody. Welcome back. I am really excited to introduce our next speaker, keynote speaker, Professor David Hernandez, Associate Professor of Latino Studies at Mount Holyoke College and co-editor of the Critical Ethnic Studies, a reader. Professor David Hernandez will reflect on 4 years of Trumpism in migration enforcement, during which the administration used both blunt and refined instruments to terrorize migrants and their families, as well as assail lawful forms of migration, including but not limiting to the suppression of the asylum system. He will situate the Trump era in the context of previous administrations and the long-term consolidation of power over non-citizens. Dr. Hernandez is an associate professor of Latino Studies at Mount Holyoke, who specializes in immigration policy, detention, and deportation, and Latino A history. Dr. Hernandez earned his Bachelor's of Arts in Business Economics conferred with high honors from the University of California at Santa Barbara, a Master of Arts in American Studies from the University of New Mexico, and a doctorate degree in Comparative Ethnic Studies from the University of California at Berkeley. Dr. Hernandez focuses on research on immigration enforcement, in particular the US detention regime. He is completing a book manuscript on the institution tentatively entitled Alien Incarcerations, Immigrant Detention, and Lesser Citizenship. The book examines the racial genealogy of immigrant detention in the United States, traces the long-term consolidation of detention and deportation powers, and situates this mostly obscured institution at the crossroads of migration and prison scholarship. Dr. Hernandez is also the co-editor of the anthology Critical Ethnic Studies, a reader. He has published works in the Journal of Race and Policy, NACLA, Report of the Americas, and Perspectives in Mexican American Studies. His article, Pursuant to Deportation, Latinos and Immigrant Detention, was recently reprinted for the second time in Governing Immigration Through Crime. And he has written numerous reviews and review essays in American Quarterly, Aslan, Contemporary Sociology, and the Law and Society Review. He has received research fellowships from the National Science Foundation, the Ford Foundation and Social Science Research Council, and the Center for Latino Initiatives at the Smithsonian Institution. We're so happy to have you here, and welcome, Dr. Hernandez.
Thank you, Claudia, for that long introduction. You didn't have to read all that. I'm going to share my screen. I do have some slides, so I'm going to do that first before I begin. And then I'm going to put myself in presentation mode. Okay, so you should be able to see my slides, and please speak up if you can't. And again, thank you for the organizers of this terrific event with its rare focus on one of the more critical, complicated, and stealth issues of our time, migrant detention. I am David Hernandez. I teach Latino Studies at Mount Holyoke College. I appreciate the interdisciplinary nature of this symposium and the collective commitment to fairness in migration, as the Dean said yesterday in her opening comments. That is clearly on display. I joined yesterday's events, which were excellent. There was terrific breadth in presentations and even hope emerging out of some awful policies. Today's panel was equally terrific, so my apologies for any repetition given all the amazing speakers today. I'm just gonna move something. Okay. I thought I would frame my presentation around an overwhelming sense of whiplash, of being jerked back and forth again over the last 20 years of researching migrant detention across changing presidential administrations, but also due to the policy fits and starts and deep contradictions within single presidential eras. Some of you might remember that on April 11, 2017, before his Border Patrol officers, then Attorney General Jeff Sessions stated, "This is a new era. This is the Trump era." The opportunity to reflect on the changing of the guard on potentially the end of the Trump era, I see this as an opportunity to cleanse myself of the last 4 years and, like you, to prepare for the next 4. Since Inauguration Day, Joe Biden has wasted little time in proposing new legislation, rolling out new policies and executive orders, and setting a different tone than Donald Trump. But as practitioners and advocates, students, migrants, and maybe some family members of detained migrants, Let us not forget that Joe Biden was part of the Obama administration, which formally deported more immigrants than any other president before him combined, for which Obama has been tagged the deporter in chief. It was Obama who ramped up the most devastating deportation machine in US history, setting the table for Trump-era enforcement. As such, there is reason for both hope and skepticism, because merely the absence and decline of Donald Trump does not in any way suggest that the remnants of the Trump era have been washed away. So there's much to think about in terms of the transition of administrations, status quo responses to migration issues, as well as the long-term consolidation of power over migrants in the detention and deportation regime. So today I will speak about the issues in this order: Trumpian rhetoric, blunt policy instruments, family separation, the assault on lawful forms of migration, historical examples of detention crises, and a little bit on Joe Biden. And we can all discuss things at the end. Excuse me. So what can I say, Donald Trump? You had me at rapist. In June 2015, then candidate Donald Trump descended down the escalators of the Trump Tower to declare his candidacy and introduce an anti-immigrant and often anti-Mexican framework that would guide his campaign and then his presidency. We all remember this. He said, quote, "When Mexico sends its people, they're not sending their best. They're bringing drugs, they're bringing crime, they're rapists, and some, I assume, are good people," end quote. This was a long downward journey where anti-Mexican rhetoric would surprisingly be revived at the lowest ebb in Mexican migration since the early 1970s. Indeed, Trump would declare a national emergency along the US-Mexico border in order to pilfer military funds for his pet project, the border wall. In doing so, Trump returned the figure of the Mexican criminal, or bad hombre, to the center of the popular imagination. That's because anti-Mexican is a catch-all for anti-Latino, which is a catch-all for anti-immigrant, and it would become the central rhetorical and policy strategy for the next 4 years. Especially in regard to immigration, the vitriol of the president would become one of the signature features of the Trump administration, one that both motivated and sometimes slowed his agenda. Demean, blame, refuse responsibility. This is the former President Trump's primary skill and strategy of first resort. The presidential insults, inhuman comparisons, and falsehoods about migrants of all kinds are too ugly and too many to list. Cumulatively, however, they create a logic for retaliation, justifying and promoting state-sponsored as well as vigilante forms of violence that can be framed as patriotism. We've witnessed this many times over in everything from mass shootings to an emboldened racist citizenry. While the Trump rhetoric is but one aspect of his stance on migration politics, it's something that should be reckoned with, as it has moved or motivated one of the great engines of policy in the United States, and that is anti-immigrant sentiment. Inspiring his base from voters to vigilantes, and as we saw on January 6th, turning voters into vigilantes, the Trump rhetoric soared from his bully pulpit and spread everywhere. It continues to inspire institutional and individual violence, and not just at the Capitol. Remember the racist mass killings in Pittsburgh in October 2018, Gilroy, California in July 2019, and a week later in El Paso in August 2019. These were responses to presidential calls to arms rooted in anti-Latinx sentiments, but easily expandable to other racial groups and other political issues. Anti-immigrant rhetoric, of course, is married to policymaking. When Trump said of immigrants at the southern border, "These aren't people, these are animals," the president was referring to the MS-13 gang. But to Trump and his followers, MS-13 is synonymous with Central Americans, which are easily conflated with Mexicans, who are easily represent all immigrants, and who are at the root of Trump's anti-immigrant thinking and policy. And let me say, persons accused of being gang members, much like persons accused of terrorism in the Bush years, these are very blurry concepts in law enforcement. But if migrants are animals and not people, then what kind of treatment should they expect? Also at the intersection of rhetoric and policy, yesterday one of the speakers discussed the woeful testing and limited vaccinations of migrants in detention. These policy decisions contributed to the spread of the coronavirus. The same goes for COVID-19 relief. The 2020 version last spring excluded 1 million migrants without social security numbers and the people married to them, including citizens who pay their taxes together. These aren't medical or economic decisions, but these are political ones based on perceived anti-immigrant sentiment among voters. The same went for Obamacare in 2010. Undocumented immigrants were excluded even if they could afford to pay for it. This is the logic of race, not the logic of medicine. In 2018, when Donald Trump infamously referred to Haiti and African nations as we know this, shithole countries, he was building his argument against economic, familial, and humanitarian migration. Trump was also using a rhetorical tool, a spatial category, the country of origin, as a driver of immigration policy. Country of origin has always been used as a euphemism for race. Think of Chinese exclusion or Japanese internment, policies that began spatially but were expanded racially to the Asiatic Barred Zone in 1917 or to Japanese American internment. US citizens represented 2/3 of all Japanese Americans detained. The National Origins Act of 1921 and 1924, which created the national quota system, which defined immigration policy for half a century, embraced this euphemism and accomplished a form of racial engineering that President Trump constantly aspired to. Country of origin or undesirable or shithole countries is an especially important policy tool in an era where traces of race have, in theory, been removed from the law or deemed unconstitutional. These forms of rhetoric drive policy, from the Muslim travel ban to the Remain in Mexico policy, and even what Trump has called the China virus. Donald Trump's racial chestnuts, and again, I'm sorry to repeat this, shithole countries, bad hombres, rapists, animals, infestations, are not only steeped in racism, but they reflect the very basis of all racism. That is, I will harm you because of what I believe you inherently are, based on arbitrary and repackageable stereotypes. These beliefs about inherent qualities of certain human beings provide cause for racist actions and racist policy. Excuse me. According to the White House press secretary, Jen Psaki, Joe Biden recognizes this and insists that rhetoric is paramount. Quote, words matter, tone matters, and civility matters, she said. Even Stephen Miller, the architect of many of Trump's most racist policies, agrees. Quote, the struggle over the lexicon is actually the central struggle, end quote, he says. The move away from alien and illegal alien discussed yesterday is at once a change in tone, and I want to suggest potentially a change in policy. All this is to say that it's not just Trump's foul mouth and the real violence that comes with it. You'd think that would be enough. But crude ideas demand crude policy solutions. Walls, cages, travel bans, bleach, not testing for the coronavirus, not counting migrants on the census, and of course, not counting votes. These are all deranged avoidances of reality. Now, I don't want to take all of our time with discussions of rhetoric, especially Trumpian rhetoric and evasiveness, so I'll return us to enforcement policy. Whereas Trump's discourse on migrants seemed to separate him from recent administrations, his policies are more of a continuance of a presidential status quo that's lurched forward for decades and decades. Now, this image is a violent one and hard to look at, and I debated whether to use it, and I promise I won't leave it for very long. But it's representative of the brand of cruelty and the cartoonish packaging of the Trump administration and its policies. Trump's behavior, what I call a raging form of the status quo on immigration, serves to block our historical memories of previous administrations, as well as highlight Trump's more blunt instruments of migration enforcement. Again, the Muslim travel ban, a border wall or fence, and the infamous family separation policy. These severe and vulgar strategies mask the Trump administration's more subtle, technical, and refined innovations wreaking havoc that wreaked havoc on migration policy writ large. As promised, let me move to another image, no less cruel actually. In Trumpian immigration discourse, history is made and unmade daily via the president's Twitter account or through a barrage of administrative actions, rule changes, proclamations, and executive orders. President Trump would declare his version of the truth about migration one day, deny it the next, and reassert the original thought a day later, hence the whiplash. Migrants and advocates would push back too, often using the courts or the streets to check the administration, which then would return with another volley of unconstitutional policies until one passed legal muster. The whiplash pace was overwhelming, contributing to what historian Robin D.G. Kelly calls, quote, a gaping deficit in historical thinking, one that has infected contemporary political discourse and impoverished our capacity to think beyond spectacle. Take family separation and zero tolerance. For example, you all remember the fiasco in spring 2018. In a few short months, the Trump administration issued a zero tolerance policy designed to separate migrant parents from their children through the criminalization and prosecution of border crossers. The policy was implemented to the traumatic effect of separating over 2,800 children from their parents, although halted after a short period of time, its brevity as a policy pales in comparison to the permanent harm and injury inflicted deliberately and with foresight as a tool of deterrence. Now, if you heard the audio recordings of children wailing, parents helpless, enforcement personnel mocking them, and translators speaking to them in Spanish, it was horrifying. This is the logic of deterrence. If I harm Ravi today, I can prevent Claudia's migration tomorrow. That's how it goes. In your professions in particular, you are more than well aware of the damage inflicted, especially to the mental health of parents and children, that continued through the bungled reunification process that followed, taking months, with some children separated permanently from their family members. Now, as it turns out, the story didn't end or even begin there. The Trump administration had also piloted the program a year prior and had already separated 1,500 children before the program even began officially in April 2018. And after the program's termination, Trump's DHS, Homeland Security, continued to separate children from family members, over 1,000 at last count, because it doubted the veracity of the family unit or did not recognize the broad range of non-parental family members that accompany children north to the United States. Now, if all you have in the world is your sibling or your stepmother or your uncle or your gender non-conforming partner, then that is your family and you should remain together. Now, these more outrageous and blunt policies that I just explained, the family separation policy, accompanied by Trump's venom and contempt for migrants, are really a clever bait and switch. They have masked a shift in focus from unlawful migration, although this is invoked all the time, the bad hombres, to a redirected assault on lawful forms of migration. To be sure, one of the most important facts of this whole discussion, and as all of you know, but not everyone else in the general public necessarily, is that seeking asylum, seeking refuge is a lawful process, especially needed in an era of global violence and climate change. Acquiring asylum is not easy, but is theoretically a form of humanitarian relief within everyone's rights. Prior to the pandemic, Trump stifled humanitarian relief. He lowered refugee resettlement to its lowest rate on record. He ended the Central American Minors Program that allowed youth to seek asylum from their home countries so they wouldn't have to join a caravan north. He made attempts to change the calculus for what counts as a credible fear and began measuring judges' performances by the amount of cases they closed. Volume is critical, Attorney General Jeff Sessions said. Trump even ended child-sensitive questioning for children's asylum proceedings. One asylum worker called these administrative and bureaucratic strategies death by 1,000 paper cuts. Now, on the heels of family separation, The smothering of asylum was an incredible doubling down by the Trump administration. Other programs like Remain in Mexico or metering or the various Safe Third Countries have created a bottleneck at the US-Mexico border, compounded by COVID-19 and the March 2020 Centers for Disease Control rule that closed the border, Title 42. I recall speaking with yesterday's moderator, Megan Clute, shortly after the 2016 election, 4 years ago. And Megan told me with foresight, and I paraphrase, "Well, there goes a decade of lawyering," she said, talking about all the hard-fought changes and avenues for relief that would go away in the Trump era as he had his blunt policies, but his refined policies meticulously ate away at these things. And some of you have probably seen in the New Yorker or the New York Times, attorney Lucas Gutentag has tallied all of these and kept a database of all these changes of the Trump era, over 1,000 of them, that hopefully they can be used to undo them all. Other lawful migration statuses were also rattled. Recall that Trump also ordered the end of DACA, he ended temporary protected status for 6 nations, and sought to narrow the naturalization of migrants in the military, and naturalization in general, by tinkering with the centuries-old public charge designation. The list is overwhelmingly and goes on and on. In short, seeking citizenship or entry through lawful means is becoming more risky and dangerous for the future of one's family. It weaponizes not just immigration and customs enforcement, not just ICE, but also citizenship and immigration services, USCIS, which in some jurisdictions produces as many as 1/3 of all notices to appear for deportation proceedings. DACA in particular produces a stressful form of whiplash because it was turned off and on and off and on by courts and a stubborn administration. It was also used as a pawn in border wall negotiations. One DACA recipient, Corina Aribe, writing in the New York Times recently, referred to the, quote, roller coaster of emotion caused by the last 4 years of gamesmanship with DACA. In addition, Trump alluded to other long-term targets as well, recall the president's tantrums over chain migration, or the diversity lottery, or birthright citizenship. All of these efforts, tinged with racism, were meant to slow down, create barriers, and make lawful entry or citizenship impossible through bureaucratic administrative processes, not through legislation. These executive efforts represent, in my mind, an executive dissolution of Congress, with end runs upon end runs. As well, Trump's assault on legal migration is a form of demographic racial engineering on a grand scale, and an example of Trump's authoritarian white nationalism. Now let's talk historically for a bit. The issue of immigration is bound up in the nation's founding laws, in every military conflict, the Cold War, civil rights movement, in economic booms and busts, and in regional xenophobia that often becomes national anxiety. It's never one of these issues, but all of them, a continuum of fits and starts, resulting in a cumulative consolidation of power. A focus on one issue only, oftentimes framed as a crisis, detracts from others, as well as the big patterns, the legal precedents, and the resilient mobility of migrants to build lives after arrival and despite hostile receptions. Now, let me show you a series of enforcement crises that I look at in my research, where detention and deportation of non-citizens serve as the primary technologies of enforcement. Now, I intentionally mean for this slide to be a blur because there's so much there, because these events are rarely seen together. One reason is because these moments are often framed by national crises, which require unprecedented and at times outrageous responses. The immigration crisis is an amazing tool that prevents us historiographically from connecting the dots and seeing the continuous patterns of enforcement and accumulation of power over migrants. As unique as Donald Trump is as a person, it doesn't take much historical perspective to widen the lens on the Trump administration and to provide context for the administration's penchant for dealing from the bottom of the deck. in immigration matters. Any discussion of the Trump administration's unique, but not so unique, imprint on immigration policy must include previous administrations as well. Was family separation, for example, an invention of the Trump administration, or to what extent did the Obama administration or both their predecessors separate families first? Thinking more broadly, isn't separation a part of all forms and stages of migration, from historic displacement abroad to border processing to detention and deportation, and even for those in sanctuary? And while Barack Obama earned his title, Reporter-in-Chief, for formal removals, if you're looking for presidential thumbprints on immigration enforcement, it really depends how far you want to go back. And here I provided a slide with 50 or 60 years of highlights illustrating this point. We could drift further into history and discuss family separations parallels with Indian removal, with slavery, and the banishing of impoverished families. In the immigration context I'm suggesting, we've actually been meandering back and forth in a dizzying fashion with child incarceration, separation, and family detention for some time. Now, the first family detention center in the contemporary era was the 84-bed Berks County Family Residential Center in Pennsylvania, opened in March 2001, converted from a former nursing home. It was a licensed facility until 2016, when it had its license revoked. Now, one of the 3 current family residential centers operate with permanent state licensing, which was an element of Trump's executive orders and rule changes and proclamations to allow rapid expansion of capacity. Prior to 2001, families were generally kept together, processed, and ordered to appear at future immigration hearings. But some were detained together too, and some were separated for having committed crimes or if there were doubts about the truthfulness of their family unit. This is to say that separation occurred before and alongside family detention, and it's never gone away. In fact, there are other immigration-related examples of family detention that predate today's model. One of the most infamous is Japanese internment during World War II, run by the Department of War, but also immigration authorities. As well, the US has run its own family detention camps for processing or rejecting refugees and asylum seekers in Europe and at domestic military bases in several states: Arkansas, New York, New Jersey, Pennsylvania, and California. It has also used its current or formal colonial possessions in Puerto Rico, Guantanamo Bay, Cuba, the Philippines, and Panama for family detention. Basically, we've always had some form of family detention because families always migrate together. They flee danger and other calamities together. They cross borders to once again be together. Now, I should also add that family is often narrowly defined as parents and children, and sometimes just mothers and children. There are all sorts of family units, biological and non-biological, with and without parents, and where other discriminations such as homophobia might impact their eligibility. Now, there are so many experts on these topics here today that I personally want to hear from, so I will begin to close and move us to the discussion. Let me have a glass of water first. Will Biden deliver? Or what will Biden deliver? The Biden administration thus far, as it moved from campaign to governing, has been an exercise in whiplash, making promises and then tempering them with limited changes and a wait and see attitude. In December 2020, Biden began walking back his on day one promises, wanting instead to move slowly to rebuild systems for processing migrants. He did so, like his predecessor, by invoking the spectacle of 2 million immigrants potentially at our border. With the exception of Biden's task force to reunite families separated through zero tolerance, many changes are limited to simply exploratory reviews of past policies of the Trump administration. This is a far cry from substantive change. Like other administrations, he wants to hold all the cards. For example, maintaining COVID-19 restrictions at the border, Title 42, or not ending the Remain in Mexico policy, but not adding to it, and then slowly processing the remaining 25,000 migrants languishing across the border in a sort of mini version of metering. As well, his 100-day pause on deportations was blocked in the courts, and that was somewhat out of his hands. To be fair, on the first day in office, Biden accomplished what Trump failed to do in 4 years by initiating immigration legislation. Whereas Trump constantly evaded Congress by deploying executive orders, rule changes, fee schedules, and international agreements to complete his end run, Biden's US Citizen Act of 2021 engages the deeply divided elected body. He has also used executive orders to end the Muslim ban, halt the construction of the border wall, and undeclare the national emergency that facilitated its construction. Comprehensive immigration reform legislation, as we know, or CIR, as we know it, is the non-starter of our generation. Many have tried and failed. Whereas CIR is an opportunity to engage Congress and constituents, I have always been skeptical because of the political challenges from all sides and the sorts of compromises that make such legislation unpalatable. But for politicians, CIR is an ideal protective screen, permitting elected officials to champion their big ticket items, maybe legalization, maybe increased border security, maybe expensive technological surveillance, and then they can also rail against the compromise, so they win both ways. That's why Biden and immigration stakeholders seem to be open to a step-by-step approach with small pieces of legislation that won't generate as much backlash from anti-immigrant forces. Hopefully, we will see some of this. Now, as much as I spoke of presidential status quo in immigration policy, I'm not one to equate all presidential administrations. Trump was different. Biden is different. Elections have consequences, sure. And I'm not the first to say, I'm the first to say that I felt relief, albeit delayed, after the election and ultimately on January 20th. But I do fear that the Trump era was so horrendous and dropped the bar so low that Biden will be judged in relation to Trump instead of what is right for immigrants, what is right for your clients, and what is right for all of our neighbors. Thank you.
Thank you so much, Professor Hernandez, for those remarks and for going through that history with us and leaving us with, things to think about as we go into a new administration. We do have a question that has come to us that I want to pose to you on your thoughts. How should the community organizing that happened during the Trump administration be utilized to push change now, as opposed to believing that, things don't need to, that momentum doesn't need to stay?
I think they already know that. I mean, I think hearing from Ravi is that I think people shift gears immediately, and they know. I remember think of when DACA was passed and all the efforts that I remember teaching students that pre-DACA and all the things we did for them. I was teaching in California at the time, and all the things we did for them. Then it passed, and immediately they started advocating for their family members. Immediately they started advocating for their parents. Then some of them even went so far as infiltrating detention centers. So I think it's a new administration. You hold their feet to the fire based on the principles that you've always had, that immigrants have a right to be here, that whatever your wish list is, that entry shouldn't be criminalized, that there should be open borders, whatever your pool is. I think you just go back to that. It doesn't mean it's the tone is different. I think there's people listening, but they still we need to hold their feet to the fire as well. But I think I would follow the community advocates first, because they seem to be on it already.
Thank you. We do have another question from an attendant. This is from Maria Cristina Cuerda. She says, I always felt that when Obama shifted his enforcement priorities to focus on immigrants with criminal records, he was playing into the narrative that undocumented people are criminals. Obviously, we know that ICE continued to pick up whoever they wanted. So when millions were deported, the natural conclusion was that those millions were criminals. What do you think?
I mean, that's a great question. And part of the new because Biden is trying to reinstate those kinds of priorities in ICE enforcement, and so it's on the table. The issue with that is I agree with the question because the questioner, because Obama also manufactured those criminals. I mean, if you are prosecuting people for unlawful entry and even re-entry, then you're making criminals out of what is essentially something that's part of the definition of certain kinds of migration. And so so there's that aspect of it, the sort of manufacture of criminals and people mentioned yesterday and today, aggravated felonies aren't necessarily even felonies, et cetera, et cetera. And so there's all kinds of criminalization that takes place that makes you question who is a criminal, what's an aggravated felon, and who's actually being deported for criminal reasons. And so I'm concerned with that. I think also that as long as you marry criminalization to these policies, you're still going to have what Robbie called that good and bad immigrant, that there's some that are deserving, they haven't done these bad things, and others that are. And some of these crimes are things that we might forgive and are in different states, certain kinds of drugs, et cetera. And so it's very haphazard. And so I think the biggest thing we can do is to decriminalize things, to try to move people out of that frame, because it's an unfair one, it separates people, and it's arbitrary in lots of ways.
Right, and I think it's also worth mentioning that in the context of immigration, criminalization is so different in terms of its definition when you're sort of referencing a person's, if they have any immigration, any criminal records. There's both the sort of perspective of, the good and the bad sort of immigrant, and then when you're actually advocating and representing somebody, there is a different way that immigration deals with criminal records, and somebody might not even have to have any extreme criminal history to be deemed ineligible due to whatever they do have. So thank you for that. We do have we have questions coming in. So this is an exciting part of all of it is exciting, but this is also very exciting. Folks are curious to know about your personal opinion on how immigration affects elections, because it seems that immigration is one of the main issues focused on in debates recently, and often in elections, it's a topic that comes up a lot. So what is your personal opinion on that?
Thank you. That's a great question. The tough part about immigration and elections and electoral politics is that immigrants can't vote, And when the focus is on electoral politics, it makes it easy to ignore immigrants, because if they can't vote, why pay attention to their needs and issues, et cetera, et cetera. But as we know, immigrants participate in politics in all sorts of ways. They march in the streets, they vote in their unions, they're on the PTA, they have children, so they have every right, they have the right as parents to do whatever they need to do at their schools, et cetera. And so I think we need to look at a broader version of politics to understand, one, immigrant participation. But the other big issue is that immigrants are connected to non-immigrants. I think we saw this in 2012 when, part of the contradictions of the Obama administration was massive deportation, but he's the one who instituted DACA. And I think it was a shrewd maneuver in an election year, because people know DACA students, people know immigrants, they're their neighbors, they're their barber, they're their school teacher, et cetera. And so I think the sort of mixed status families and mixed status communities makes immigration, the scale of that issue, much larger than we normally think of. And so so it's still a critical issue. This is not to say that all Latinos like immigrants, because Latinos are reflected, because we know they don't. We know it's more complicated than that. But I think that it's obviously a tough political issue for the politicians, because they framed it that way. They make it impossible to be pro-immigrant, because they make it into a zero-sum game where if you're for immigrants, then you're against citizens. And the same thing like with COVID relief. If you give this family, this essential worker, a check, then you're taking it away from some sort of citizen, as if that's more deserving in a health pandemic. And so I think the logic of that separation and electoral politics minimizes the impact of immigrants and just in society and what their needs are. And it makes it easy for the political system to ignore them, the electoral political system.
Absolutely. We have another question about community organization and the backlash that some immigrants face when, you know, they come out publicly in terms against immigration. So we saw a situation like this up in Vermont, where advocates in an organization called Migrant Justice were really open about, you know, anti-immigration policies and like against against ICE and detention. And there was a lot of retribution on the part of ICE against these activists and these immigrant advocates. And then there was a whole lawsuit after that. What do you say about, you know, how to balance the potential backlash from government or other folks that might come from, you know, immigrants being open in their organizing and activism?
And that's so important. I think we saw this in 2006 when there were the big mega marches all over the country, and immigrants came out and waved the flags of their home countries, and everyone flipped out, or they changed the name of they sang the national anthem in Spanish, and people flipped out. And so people react to that vocalness, you know, and you know, that's just the way it goes. You know, I think if anything, the persons who aren't vulnerable to, you know, criminal proceedings or immigration proceedings, et cetera, we are the ones who have to help enhance that voice, have to give them the megaphone, because, and I think community organizers do this all the time, where they balance the citizens in their group with the non-citizens, and they try to work out those politics and those strategies, because if we ask them to wait, then there would be no DACA. If we asked them to wait, there would be lots of things we wouldn't have at all. And so we can't. And a lot, especially amongst immigrant youth, they're thinking in a way that's because they have different stakes in the matter and different risks, and that gives them different vision as well. And we have to listen to them. And so I would never think, I mean, I think you don't want anyone to go to a rally and get deported. So we had to come out, if that's what it's coming down to, we just have to find ways to protect them at that rally.
Right. It's about having strong coalitions supporting the effort of both, you know, people who are at risk of deportation and people who are not. What do you see the immigrant detention situation at the end of this year? Do you think progress will be made and towards ending it?
Oh boy, I'm scared, you know. I mean, it seems, you know, I've been following for so long, and, you know, they just opened up a center in Texas for unaccompanied teens. You know, we saw what Obama had to deal with in 2014 and 2016 with Central American migration. I mean, so yeah, I don't know. I'm afraid. I think the prioritization issue, the enforcement priorities is something. Again, I also think it reinforces the criminality issue, but there's a lot of people that will get released. And where I live in Western Mass, there's a man who's been in sanctuary. My class has visited him before for 3 years, throughout the entire Trump administration, because when Trump got rid of the priorities, the enforcement priorities, he had to go into sanctuary. Under Obama, he didn't. He just had to check in regularly, and that can be onerous too. Robbie mentioned going 3 times a week, and yesterday there was a great talk on alternatives to detention being just as better than being in jail, but problematic nonetheless and disruptive nonetheless. And so that, you know, I don't know. I'll cross my fingers with everyone else, and you're the lawyer, so I'm going to count on you. But you know, I'm a little worried. You know, hopefully, I mean, I think what happens though, and maybe with this kind of piecemeal legislation, is that it's like you pass DACA, and look, the world doesn't come to an end. You release people from detention, and everyone sees, hopefully, that the world doesn't come to an end, that no one's going to freak out. And so maybe we can show them that through amnesty, through these different things, that not all things go bad, you know, and hopefully that'll lead us to a way where we can start decriminalizing things and not detaining people for no reason, and force the government to, if people are a danger to society, make them make the argument, but not these arbitrary arguments because the crime they committed in their past is on this arbitrary list for things that they served time for. That to me is ridiculous.
Right. So another question we have here is, many immigrants are so exhausted by the process that once they become permanent residents and later eligible for citizenship, they do not proceed to apply for citizenship. So in a sense, they're limiting their rights and possibly exposing themselves to deportation. Any guidance to change this and encourage citizens after achieving permanent residency status?
I mean, I think we all know, as you all know, the only prevention from deportation is citizenship, and I was married to a non-citizen. I mean, she's Canadian, so it's not the target non-citizen. But I was concerned, I was concerned about at different times about, you could have a car accident or, do something bad in an airport where it's, a different kind of jurisdiction. And, I was always worried about stuff like that, and especially knowing the subject matter. But at the same time, citizenship is a personal decision, and people's, it's beyond just having papers. It's allegiance, it's loyalty, it means, it's cultural, it means a lot of things. And so I wouldn't begrudge anyone for not choosing that, but if they did, I would support them. And I mean, and people know this is why they ramp up the fees all the time on naturalization, on the costs of naturalization, because they know they can prevent people from doing that. And I think if we can pinpoint that if it's a economic issue, we should find ways to fix that. And that's fixable. You can help people get citizenship, help them get the money to get it. That's possible. But it is the protection, so it's important.
Yeah, it really is a protection. And I think it also depends on the individual and how they accomplish their residency. For some, it is really excruciating and onerous to have to go through immigration court proceedings and get relief that way, that by the time you get it, you're just like so exhausted and you've been waiting years and there's so much uncertainty. And then by the time you're thinking, what is the citizenship process going to be like? Is it going to be like this as well? And then of course, there's the whole language part of it where, they feel like there's so much now that I have to learn to be able to pass the test and all of that. And so it is extremely an onerous process for people, but we do remind them that, like you said, Navid, that this is, the best way to prevent deportation. Because even as a permanent resident, when I was a permanent resident, I knew that there were certain things that I had to be cautious of, to not get into any extreme trouble. I mean, even just, like a driving ticket or something that could potentially risk my legal permanent status and then have me be deported. So it is, we have to just educate our clients on what the process is like. We have another question regarding immigration proceedings. The issue of judges' decisions being arbitrary depends on, who the judge is, the day, the mood, what's going on, seems pervasive. What can or should we do to rectify this?
I mean, it seems like that's been that way for a long time, depending on the district you're in or the judge or your country of origin. I mean, I think there's just, that's a little out of my wheelhouse, on how to sort of understand that. But I mean, give them more discretion. I mean, it sounds like the opposite, but it seems like, give them more discretion to make decisions based on full sets of evidence, give migrants, I think it goes back to having them have counsel. So they have counsel up front, and not just when they enter court. Why not counsel when they are apprehended, like in a criminal situation, the timing of the counsel, and start that process of legal rights early, as opposed to waiting till it's too late, or just at its most challenging level. So I think that's because, these arbitrary things like mandatory detention because of certain aggravated felonies. I mean, you would think that an immigration judge's discretion, if the person blew up a building, would keep them detained. But they should also be able to determine that if a person committed a crime 20 years ago, that there's no reason to have them in jail whatsoever. but that's a tough one. I don't know exactly how to make, and you know, it's appointments. It's, or you could move it out of the Department of Justice. You know, people have talked about yesterday making them independent judges, so they're not, their boss isn't the Attorney General. That's probably would be a big game changer.
Right. Yep. And you know, as an advocate, we know that immigration judges are under a lot of constraints to produce certain numbers of, you know, denials, and they have quotas they have to meet, and they have they're, you know, accountable to the Attorney General. And we saw this when the matter of AB came down from the Attorney General at the time, who had taken this case and made a decision towards who was eligible for asylum in terms of domestic violence and people from Central America. And, you know, we saw that some judges were willing to evade or sort of not apply that decision firmly. And then there were others that were like very firm in their application because they had this mandate. And so, you know, I think really giving them more autonomy and removing them from the executive branch would probably, or to some quasi-judicial entity would make this a little bit easier. If we were all to take one step toward abolition today, what should it be?
I mean, there's all just, I mean, put the onus on for decriminalize entry and reentry. Like you said, give judges the right, you know, autonomy. And then if people have to make the argument for taking away liberty, that should be the most serious thing they have to make. It shouldn't be something that's easy to do based on just crossing a border. You know, that's too simple. And that's a tough one. The other thing about, you know, about abolition, we have to think about all the departments of immigration, not just ICE. You know, I think I mentioned that USCIS also issues notices to appear. And so, you know, we have to think of a broader view of that, but it's challenging. You know, I think on the state level that people can, I remember in California about 10 years ago, I think they changed the maximum penalty for a misdemeanor to 364 days. So it would never trigger an aggravated felony. And so I think different ways of decriminalizing things and just coming to a different understanding of what crime is and what forgiveness is. You know, immigrants, you know, I think all of us here today, everyone today has argued for the humanity of immigrants, but part of that humanity is also their fallibility. And we have to be able to forgive them, just like if I commit a crime and I serve my time, I'm forgiven, and we should do that for all persons in this country.
Well, thank you so much, David, for your time, your expertise, your knowledge, and your passion on this issue. We're so happy you could join us today. And thank you to all of the panelists that took time to talk about their work and ways we could work towards abolishing this system and engaging in both legal and community strategies to accomplish change. And thank you, everybody at the Western England Law Review Symposium. I'm going to turn it over to Caroline Foley, who will be issuing closing remarks.
Thank you.
Thank you, everyone. I've learned so much over this past couple of days. And on behalf of the symposium editors, we want to thank everyone for joining us over the
Caroline, your mic cut out.
It looks like Caroline's mic went out, so on her behalf, I am sure I can guess some of what she was going to say. We'd like to thank all of our panelists. I feel like this was a super educational event. I've been getting texts throughout the whole thing that say that. I'm sure everyone who was in attendance agrees. And we're glad that even though we couldn't meet in person, it was virtual. So it will be posted on our Facebook page for people to be able to watch. I saw yesterday's event already has 400 views, so that is great to see. And in the messaging on the side, we mentioned like ways to follow us so that you can see the articles that people who spoke at this event are going to publish. So just again, I want to thank everyone that was involved. You've heard many thanks throughout this whole event, but especially the symposium editors and everyone who spoke and everyone who came to this event. We'd like to thank you.
Can you hear me now?
Yes.
Yes, we can.
Well, since Katrin already said the thank yous, I still would like to add a couple of things to the calls to action, if that's okay with everyone. We've been listening to a lot of hard truths, especially that the US runs the largest immigration prison in the world with 200 detention centers, most of which are private, with illegal entry being the most prosecuted federal crime last year. Unnecessary detentions during COVID are putting non-citizens' lives at risk, considering the shuffling of migrants between detention facilities and deportation flights. But one hopeful aspect that we've heard yesterday and today is that community organizers and immigration attorneys are getting creative every day, advocating to get their clients out of detention through habeas, constitutional challenges, while trying to keep track of the daily changes in immigration law. As a first-generation immigrant who has been undocumented through middle school, high school, and most of college, I can tell you that the fear of being apprehended is real and paralyzing, takes a toll on your mental health, the families, no matter how much of a hard worker you are. The immigration system in place works well to keep people in the shadows and afraid. And as mentioned, today, I'm also lucky and grateful that I received meaningful representation, and now I have the opportunity to help non-citizens for the past 10 years prior to coming to law school. So as we talked a lot today, community organizing is the key, and attorneys play only, a small part in the struggle. So what can we in the community do? We can have these honest conversations because knowledge is power, but especially conversation with the communities being affected by these issues. We can advocate for Driver's License Act in Massachusetts, Work and Mobility Act, proposed by Governor Baker, because driving without a license is actually a reason why many non-citizens get arrested and detained by ICE. So if representation matters, how can we support non-citizens in having more access to representation and their fair day in court? Advocate for the repeal of USC Code 1325 and 1326 that criminalizes illegal entry. Support DACA and TPS holders who have been fully vetted by the Department of Homeland Security and qualify on humanitarian grounds to stay in the US, but they're currently in limbo since forever. Join movements to stop the expansion of ICE detention and shut down private detention centers near you. Find out what ICE is doing in your community. Because as we know, there's 200 centers around the country. So there's for sure one near you. Most importantly, see the humanity in non-citizens who are part of our community and stand by their rights. By conclusion, I don't think Katrin mentioned all of this, but join our Western New England Law Review page to find out when the symposium volume will be published and read all the amazing articles that were discussed here during the past 2 days. The recording of both sessions are in Western New England Facebook, as Katrin mentioned. And please reach out to any of us in the panel if you want to continue the conversation. Our law school mission is to serve the needs of society with knowledge, competence, and compassion. And we hope to continue to be part of this conversation. So thank you again. And I'm glad the audio worked after all. Thank you, everyone. Enjoy the rest of your weekend.